Your Lordship. And then I may be permitted to mention item number 25 of today's list. I pray for adjournment for 2 weeks, my lord, with consent from the other side.
I put a petition on.
25.
25.
I put a petition.
Miss,
A Bhattacharya.
why do you want to,
I have some difficulties, my
Mrs. A. Butter? The 2017 matter, madam.
17 matter, my lord.
You have problem for the how many years now?
Next time I will. Some problem is, yeah, my lord, this week.
Mrs. A. Bhattacharya, the counsel for the response number 1, pays for adjournment. As the same is not objected to by Mr.
K. Kulita.
A. Kalita. K. Kalita. This is the matter after?
After 2 weeks.
After 2 weeks.
Okay, India may continue.
It is in order to continue till the next day.
Item number 15, madam, with consent of the petitioners council and my lord for the ONGC. I am making a mention on behalf of IOCL. My lord has directed me on the 7th of March to gather certain instructions. That is pending, my lord, just a few more days.
Item 15, 16.
1, yes, 16 also, madam. 16.
Yes.
My lord, it may come up on 27th, my lord.
Huh?
It may come up to 27th, my lord.
No,
Because we are suffering, my lord.
Any day.
Otherwise, your lordship may allow us to take an order and, my lord.
Huh?
Any date, my lord, fast to appeal.
Because they will put this instruction only, my lord. That will suffice.
Yes.
27th, my lord. 27th of the.
My lord, next week, my lord, is a holiday, my lord, any date.
Why? What is the problem next week? What is the problem? You're very busy.
No, my lord.
On the prayer for adjournment made by Mr.
P. Bharadwaj.
G. Bhardwaj, appearing for
For the IOCL, my lord.
IOCL. This is the matter on 20?
Seven.
7.
My lord, can you direct the registry to reflect the name, standing council IOC, my lord? Otherwise, we miss the idea.
Registry to reflect the SCIOCL in the Congress.
May please lordship. My lord, I have an urgent matter. In municipal land, we have settled a market. The other party has raised objection and got some stay order. So we have filed vacation petition to be listed tomorrow.
Tomorrow difficult.
But
See, today also we are feeling we have difficult.
then let it on Monday,
Monday I am not coming.
27.
28,
And the 27.
28, 20, 27 too many kids.
Maybe
Yes.
for listing of repetition and for the response number 12, these on next week on Tuesday, your lordship is possible.
Tuesday I am not coming.
Then Wednesday, next week, Wednesday, your lordship.
Why, new case?
It's 22 matter, your
No,
lordship.
no, give a date.
No, this honorable court has directed to list the matter after 3 weeks. Almost.
Maybe.
Lordship.
No time. 8th April. 8th April. 8th April.
Please, my lord. I'd like to withdraw item number 22 and 23, my lord.
Okay. Why? What happened?
However, that's become infractuous, my lord.
Okay. That 1 month.
Yeah, my lord.
Okay. Mr.
See, Sharma.
C. Sharma, learned counsel for the petitioner, prays that he may be allowed to withdraw the writ petition as the same has become infractious. Who appears for the other side?
22 and 23.
Anyway, Miss Udas appears for the state respondent. Prayer of the petition counsel is allowed. Writ petition is dismissed as infractious.
Highly applies. My please, your lordship, I beg to make a mention for item number 26 of the daily list. Lordship, Dr.
Yes.
Saraf is engaged in this matter to argue. Lordship, due to some personal difficulties, not available today. I see.
I am objecting, my lord. It's a matter of 2019. The rate itself is not maintainable, my lord. Even on the last occasion, there is an order, my lord, that endeavor would be made to dispose of the matter. Revenues are stuck, my lord. They've indulged in electricity theft. And without availing the statutory appeal, they come before the
Okay.
Supreme Court.
Yes. Tomorrow?
Your lordship, next week,
Next week? Why next week? Okay, next week. What is your name?
And then Datta.
Mr. N.N. Datta, appearing on, submits that. You're not in the, you're not a council.
I'm a junior.
Huh?
I'm a junior of
Mr. Sharaf is also not a council. He is engaged by whom?
Mr. Kejriwal, Your Honor.
Mr. N.N.
Datta.
N.N. Datta. Submit that Mr. Dr. A. Sharaf will be appearing in this matter. However, he prays for adjournment. Full stop. On the other hand, comma, the same is objected by the SC EPDCL on the ground that there is a stay order, which stay order against the respondent. On the prayer of the councils for the parties, list the matter on 28. 28.
I'm deeply obliged.
Your Lordship, it's an urgent matter, and I pray for it to be listed tomorrow. It's in bench court, and an IO was filed. An
Huh?
IO was, an
I-
interlocutory application was filed. Because I prayed last time also, she had no water. After that, it was listed in case EMA court, and some orders were passed, but this IO needs to be heard. There are-
Regarding what? What is the matter about, madam?
It's a mother being totally harassed by her son, who is a drug addict and an alcoholic. So it's a very, very urgent matter, Your Honor, and it's not being listed automatically. Therefore, I pray for it to be listed tomorrow if possible.
Before this bench, is
If
it
it's
a?
if before,
No, is the issue a bench for matter?
it's a issue of bench for you.
Bench for. Okay, list it tomorrow.
Highly obliged. Highly.
I didn't want to withdraw.
Maybe let's not say, but I may be allowed to withdraw this matter with liberty to file a.
Why liberty?
Well, there is some lack of documents, I may be allowed.
Okay, Mr.
Image answering.
M.H. Ansari, learned counsel for the petitioner, prays that he may be allowed to withdraw the writ petition with liberty to file a fresh. Miss
M. Das,
appeals for
PW.
PWD. The prayer of the petitioner's counsel is allowed. The writ petition is dismissed as withdrawn, comma, with liberty of speech.
I can move for motion.
That
Security guard. Yes. So, where is the record?
Lordship, the record is. Trademark the relevant pages.
Have you tagged it?
I picked up a relevant page. So the basic challenge of the petition is that two clauses are not favoring them.
Yes.
That is their.
Not all the clauses, madam.
Huh?
Madam, all the clauses, madam. I will explain your lordship, madam. The lordship, pardon me, madam. On last occasion, madam, we are on 12 sheet, but we have had an additional.
Just a minute. I cannot hear you and read at the same time. What do you want to show by this?
Lordship here,
What, there's nothing here.
on 24th of January, Lordship, the earlier tender was cancelled. Thereafter, the committee was constituted on 8th of January. And Lordship, they shows that the reply was given to them on 19th. And next day, tender was floated. But the reply to the petitioner was already approved on 8th of or 8th of February.
What do you mean? What do you mean reply to the petition regarding what?
Now, regarding Lordship, their contention was that
Just a minute, just a minute. Let me read the order.
please to see.
Yes, what is the objective to be achieved by asking that the security agency should have an annual turnover of two crores?
Please to see the report of the committee lords.
Which page?
Lordship, click mark.
You too. Besides the requirement of having a 5,000 manpower, and giving marks for that.
Lordship, they did not depart anybody from.
No, it's not that. What is the purpose?
Lordship,
Why are you giving marks just like that? You want 150, your manpower needs is only 156. Why do you want to give marks to a person, to agencies who have got 5,000 manpower? What is the object?
Lordship, to see the report.
Huh?
The report of the committee. On the basis of that, Lordship, it was revised. Earlier, tender was issued in January 2024. Then on the complaint of the present petitioner association, the committee was constituted, and on the report of the committee, Lordship, the revised tender was issued.
What is the, you see, how did you come, you see, this 5,000 and this 100 crores and all this. How did you come about this figure? How did you come? What are the deliberations on coming to this figure? That is what, we are not on the decision taking. We are on the decision making process. So, why do you need to give marks to a person who has got 5,000 security guards, to a company that has 5,000 security guards, when your need is only 156?
The purpose for inserting this clause was that, but if you call some unscrupulous tenders are being filed.
Where is that? Are you saying it from your own head, or is it here? Is it backed up out here? What you have said just now from some unscrupulous persons, is it there?
It's not written.
Then how can you say something which is not there?
Lordship, please come to page 30.
You file an affidavit.
No, Lordship, come to page 35
Page 35 of what?
of the writ petition.
Yes. Yes,
Lordship, come to clause 3.
yes.
Turnover, annual turnover of the company or any of the one of the last 3 years. A, up to 100 crores. Up
Ah.
to 100 crores, they will get 2 marks.
Ah.
Then between 1,000 to 100 to 200 crores, 5 marks. And above 200, 10 marks.
Why? Why should they get so much mark? What is the purpose?
The purpose is to, Lordship.
So if there is a tender process and you take part, and on the other hand, Mr. Bill Gates is there, then what happened?
No,
His marks will be, because he's the richest man, one of the richest men, he'll get.
no, Lordship.
So where will you stand?
No.
Out here, the issue is, the entire contract value is around 1.56 crores. Why do you need a 200 crore company?
Lordship, other.
Another thing, you need only how many security guards? 156. Why do you need 5,000? Why should those 5,000 companies be getting excess marks? I want to know the basis for coming to that decision. If you
That
can
is
give me the basis,
the
show me where the basis.
No, that is the only report.
No, because please read it carefully. Out here it is said, after due deliberation. I want to see those deliberations.
That is the report, Lord.
No, it is here.
No, Lordship, that is the report.
Yes, then that means there. So that deliberation was in the air. There's nothing written. Correct. Now we do not know. Now, you see out here, a revised. Wait. After detailed discussion and deliberations, the committee recommended the following. Now, what are those detailed discussions and deliberations? That is what I want. Not the decision. I want the decision-making process. The object sought to be achieved
By the committee.
by that decision. That is what I want. I cannot, this court cannot challenge this, I mean, have judicial review of the decision. Only the decision making process.
That is the law.
When to do that. Right. You file an affidavit, give the reason.
I'll file affidavit.
Yes, Mr. S.C. Kayal, learned counsel for the respondent number 1 to 4, has brought the official reports and a perusal of the recommendation of the 3-member committee on the tender documents, which is reflected, dated 14 to 2024, states that the recommendations have been made after detailed discussion and deliberations of the committee. Also, the discussion and deliberations have not been, are not a part of the official records. Mr. S.C. Kayal shall submit an affidavit on behalf of the respondents number 1 to 4, giving the discussions and deliberations of the 3-member committee for making its recommendation on 14 to 2024. 2 weeks time is granted to file affidavit to position. This is the matter after 2 weeks. Interim order to continue to the next. Supplementary motion item 28.
This is also about time frame also. Diego will appear also in this
Huh?
case. Diego will appear in this case is on next.
What is the matter?
Same issue, my lord, that the balance sheet and the IT return has not been certified by the chartered accountant. Regarding, my lord, the issuance of IMFL license, my lord, to the NIT.
So what? There was an earlier case.
Yes, my lord, I have annexed, my lordship has considered
Where?
that, my lord, at page 94. That should make on the page 95. Last line.
Your technical bid was accepted.
Technical bid was, my lord, rejected on 2 grounds, that the affidavit which I had uploaded, that I had uploaded earlier. And secondly, few pages of the, my lord, tender document has not been signed. But the same is the case of the respondent number 5, but that has been ignored. I have submitted my objection before the authority, but they have not considered. Same, my lord. In fact, here what happened, my lord, firstly, the tender was issued. The two participants, myself and the respondent number 5 were there. Then both of these petitioner and the respondent number 5.
Show me where your tender has been rejected. Your
Uh,
technical bid.
Lordship,
on the
you find
ground.
page 73.
Page 73. Yes.
Serial, first, table is, those who are selected qualified. Serial number 2 is the respondent number,
73,
Fine.
there's no, what serial number? What?
serial number 2 is the respondent number 5. He
That's
is
Sitananda Hazarika.
Hazarika, he has been qualified. The chart is under the qualified bidder. Then second, chart is for disqualified. I am at serial number 2. And the ground of
Who is
rejection,
Rishabh Kumar Barwa?
lordship. He is
That's petitioner.
lordship. And my ground of rejection will find, my lord, page 76.
Sitananda Hazarika, respondent number 5.
As per number 5.
Yes. Then,
My ground of rejection, my lord, the technical bid evaluation. That starts from page 74, lordship may come to page 76. Serial number 3.
yes.
Affidavit regarding no exercise of license having previously submitted. And secondly, signature of the bidder not.
No, your name is what? Your name is Rishabh Kumar Bora.
Rishabh Kumar Bora.
Okay. Affidavit regarding no excise shop license having Previously submitted. Okay.
My lord, here what happened, my lord, initially the tender was issued, two participants were there, both were found to be disqualified on, my lord, some grounds, so therefore there's a, my lord,
Retender. Retender.
retender. And accordingly, those documents which were earlier uploaded, my lord, same has been, my lord, given to them, so that is the objection. So far as I am concerned, but so far as respondent number 5, his documents I have given, my lord, those are also, my lord, uploaded, my lord, earlier. Apart from, my lord, the RT, my lord, IT certificate and the IT return and the balance sheet are not.
Affidavit regarding so you have not submitted this affidavit.
I have submitted, but same was submitted on the earlier, the first, initial tender.
You have to submit a new one. How can you?
No matter that is. my
The
lord,
same document can be submitted twice.
Yes, but because those were returned to us.
So you submit it again.
Lordship. Similarly, he has also done, respondent number.
So
5
you will
as
have
well.
submitted it again.
Yes,
Then
because those are valid documents, affidavit, only
Correct.
originals are with
Ah.
us only.
So-
And second is signature of bidder not found in some uploaded documents. Well, there is no clause that in the uploaded document signature has to be there. Rather, it is in the original documents when I submit, there the signature has to be there.
there's nothing in the NIT.
Nothing in the NIT.
So you have made a challenge to that.
Lordship. And same is the case, well, he also suffers from the, well, if it is said to be, well, defect, same also suffers.
Suppose for which one? Two.
Respondent number
Oh.
5, both, men,
Both. Same.
both, same.
That is a question they'll have to answer.
Lordship. His documents are, I have given, my lord.
So you have put a challenge to your disqualification. also.
Disqualification as well as, my lord, his acceptance.
You are here.
Yes, sir, Lordship. So in this matter, Mr. Dido, he's supposed to appear. He's of legs, Your Lordship. After some time, Your Lordship. After some.
After some time.
Okay.
My lord, I have for the writ petition.
Huh?
I am for the writ petition, they have my item number 1 only, my lord.
You are for the writ petitioner.
My lord, only item number 1, state vacation petition has been filed. In other, item number 3, sorry. WBC 30044. So I have filed my reply also, but in this case, record is very much necessary. Because
My Lord,
I make very for the department of my.
Yeah, your affidavit is ready.
only problem is, my Lord. Their tender has been found defective by the authority. No document has been furnished. License has been expired. Those documents has been filed. Their tender has been rejected. Then everything has been approved in my favor. I have submitted a mining plan, clearance certificate also to submit. Because of the interim order, the authority has not been granted me the
What is the interim order?
interim order is, my Lord, pays. My certificate petition, my Lord. There's 79, man. Nothing, my Lord. They did not furnish any document in the tender application, my Lord. It's comparative statement is clear, my Lord.
June 23.
yes,
Environment clearance certificate was not.
No, we submitted, yeah, I annex here also, my Lord. We submitted the authority environment clearance certificate. I
When?
annex here.
When?
Yes, I annex here, my Lord.
When? Which date?
It is on, my Lord. It is on 17/6/2023.
Environmental clearance.
Yes,
Yesterday on last day on the.
page 72, page 72. I annexed. It is the duty of the government, they have come forward, but they are taking time. We are furnishing the documents, my Lord.
Huh?
When if the case is added, the absence of the environment clearance certificate.
So they have given 17.
Only problem is whether loss of locality, their rate petition, whether their tender is valid or not. Authority has
that is
given
challenged
the
by,
finding,
and
authority has given the finding, if a loss of locality comparative statement, pays, my Lord, 28.
Anyway, why have you come only now challenging this
So
order?
I filed earlier.
Huh?
I filed earlier. I filed it on,
No,
Because
I
we are
was
waiting-
filed in 24 only.
because we are waiting for that British authority has taken some step. But they are
Anyway,
not taking
you-
any steps. That is why you are waiting.
Anyway, let him file his affidavit now.
It's a one,
It
one-
will,
one- yes, my lord,
it will be in your favor.
my lord.
It will be in your, has to be in your favor.
Yes, yes, my lord.
So it
One
will-
will take-
Mr. Council, whether it's 1 week or 2 weeks, I don't know. Anyway, when can you file? Within, by this month? You file within a week? In 10 days. Okay, right. Mr. P. Nayak, Learned Council appearing for the, which department? BTC submits that the affidavit is ready and it will be filed within 10 days. Anything from your side? Nothing.
Implementor earlier shall continue.
Huh?
Implementor pass earlier shall continue.
That's,
My lord,
can you bring the record on the next date?
my lord, I filed this petition under Article 226 3 of the
That is no
Constitution.
longer exists, my lord.
But they are not filing even extension petition, my lord.
My lord, Supreme Court has already cleared
My lord.
What?
that regarding 226(3), my lord.
No, when? That is a different, that is a different thing. That
This was
Supreme
filed a
Court
petition
judgment
at
is not with regard to criminal cases.
My lord, automatic
It-
extension.
It's not on, it's not
Yes,
with regard to two
No,
to
that is
60.
also referred, my lord, probably not decision has not been.
No, no. Yes, but it's with regard to that criminal thing.
That is
Whether
automatic
that,
extension.
whether it will be
Automatic-
extended beyond
automatic
6 months.
extension. Is not given.
Anyway, can you give me that? Because we are having a 3 judges full bench here
Yes.
in Guwahati.
226.
2 to 60 is going to be decided. Can you give me that judgment that you are mentioning? Since you have it, give it.
So that is why it must be extended, my lord.
There will be no meaning, my lord. Your lordship kindly see, my lord, he is
How,
saying.
my lord? They
Please
already.
do not argue for the sake of arguing and wasting court's time. This is the matter. When?
27, my lord, 27.
No, no, no. Third, on which date Mr. P. Naik shall bring the records?
That will be.
It will be 2, my lord, hearing this.
2, I think we have got.
2, my lord, because otherwise 3 will not. The 4, my lord.
You see, Mr. Council,
My lord,
I
four.
wish we,
lord.
I wish we had the time,
My lord.
more time.
Yes, my
We-
lord.
we-
It will be 4.
Unfortunately, we're not computers.
Yes, my lord. It will be 4, my lord.
Next,
Implementor pass earlier shall continue.
interim order to continue till the next day.
Maybe Lord. The matter parting regarding my lord settlement of the fishery matter. The respondent number 2, my lord, the managing director of fishery department of NIT, my lord, 8/2/2020. 2020, madam. For settlement of my lord 58 number, Laupani, Minmahal in the district of.
Fishery, okay. Yes, so.
Thereafter, my lord, here the my lord, the petitioner along with the private total 5.
Fishery settled with whom?
Initially settled with by the private respondent, my lord. That was
Respondent number,
respondent number, my lord, 7, my lord.
by settlement order dated,
Settlement order dated, my lord, 22/5/2020.
22/5/20,
Yes, my lord. That order was
challenged
challenged.
in WPC number
WBC number, my lord, 3454,
3454 of,
2020, my lord.
then what happened?
Thereafter, my lord, this honorable court disposed this matter. High
But-
order, my lord. 19/4/2022.
9/10/22,
19/4, my lord.
19/4.
2022.
Then
Set aside the
settlement.
settlement, my lord, and directed the authority to settle to me because my bid was 11 lakhs and the private respondent bid was, my lord, 7.5 lakhs. 7.5 lakhs, my lord. And thereafter, my lord,
And you are 11 lakhs.
yes, my lord, I mean 11 lakhs, my lord. And thereafter, my lord, when the In meantime, in part, in terms of the honorable court order, the fishery was settled with me, my lord. I order dated, my lord, 21/6/2022.
Order dated?
Settlement order, my lord, next settlement 21/6/2022.
22. Then
When the settlement was issued in favor of me, my lord, in terms of the honorable court order, I deposited, my lord, this money. And in meantime, my lord, the private respondent filed the appeal, my lord.
appeal WA number
My lord, W number 248/2022.
24822.
Two.
And what was the decision of the DB?
The honorable courts, my lord, remand the matter to the
It
original.
set aside the order.
Not set aside, my lord, but kindly see, my lord, the order, my lord.
Page,
My lord, kindly see the order, my lord.
page.
Page, my lord, additional affidavit filed by the respondent number 2. Page number, my lord. 132, sorry. 33, my lord. Additional affidavit filed by the respondent managing director, my lord.
So this is the problem. Why don't you paginate with the court report?
My lord, it was subsequently, so it is not, my lord, it has the additional affidavit, my lord. And that
Mr. Counsel, there is a pagination in my copy. Okay, now whether your pagination in your copy and my copy is same, I don't know.
This copies that was present, my lord.
Huh?
This are this copy, my lord, 133.
Detail number 133. Page number 133.
Page number 133, my lord.
My page number 133 is this, the vernacular.
My lord, additional. Oh,
Mr. Counsel.
yes, I understand, my lord.
There is a running page given by the court, by the registry, which all the lawyers are supposed to follow also. So that we are in this,
My case.
I do not know, either you follow my copy or I follow your copy.
I'm following your.
You are following my copy.
It was paginated. on
If
the
you are
page
following my copy, my page 133 is this one.
Something
How
wrong.
can you be following my copy?
Something wrong.
What to do? You follow this copy. You all have to follow this. I cannot be running after you all. That's not the way the court functions.
Let it be after some time, lord.
Huh?
Let it be after. They filed, my lord. Actually, they filed, they served the copy. my lord.
Whoever it is,
Yes,
because
my
I
lord,
am not,
understood that.
it's either him or him.
Yes,
It's your,
ma'am, we
it's your duty to do it. I cannot be saying, okay, what is your, give me, let me correct my copy. I cannot. I've got
Yes,
so many other cases to decide. You all do it,
After some time.
whatever. I do not know.
Matter may timing password, but the timing Mr. R. Mazumdar is on leg.
Who's on legs?
7 and 8, Mr. R. Mazumdar.
After some time.
Ablash. 9 to 11.
Before my learned senior colleague submit, my lord, I pray for adjournment for the time being, my lord. Mr. Air is on lag in another court for the respondent side, my lord. My lord, this issue when there is about 1 crore rupees difference in the
Okay,
settlement value of these 3 deputation. Your lordship wanted the previous year
Ah,
and your lordship asked them to get the previous year record as far as the settlement values. They have collected that. That much
Okay.
I know. Even I have collected. Only your lordship has to see why this year all of a sudden is so much down.
why they have lowered the
Yes,
base price?
Yes, my lord. In my contention that it was such a situation like we could not even submit our tender. Let my friend come if he is asking for it. That is the only case, my lord. And my lord, the situation is such. Already 9 months have gone up.
Just give me the file by the time he'll come. Otherwise we keep on adjourning everything.
Only 3 months left. And my lord, to be very honest, I had some issues with the client. They are thinking that I'm not doing my part. Because only 3 months left and my friend wanted some time. I said I cannot because last night I had some kind of a strong words with them. Either case goes this way or that way, I'll try to finish it. Sometimes we are in a fixed position, my lord, because of this, especially this market case. It is 1 year.
Because money makes the world go round. Is it?
Not that, my lord. Actually, because of the business of the court or all these things, my lord, some 1 year goes by.
No, no, I'm not about the business of the court. I'm talking about the relationship between you and your client. Why you had strong words between you two? Because for them and you, money makes the world go round.
Yes, exactly. I didn't get it earlier. Yes. But it's not always, my lord.
You had tried to you had to try to submit your bill, but you could not submit on time. Or
No,
what?
no,
The bid, the box was not
yes.
there.
My lord, what happened? My lord, this is last time informed my lord. My lord, almost 25 years and lots of my friends behind over there. Everybody more or less have done this market cases, my lord. This is the first time I have heard that they put the box at 10 and there was some kind of a process which led to the putting of the bid document at 1. My lord, what I'm saying, there is no such process at all. They just put the box over there, people come and they put the thing. 10 to 1 is the time, 10 to 2. Over here, what happened? This is the excuse. I don't know how the deputy commissioner of the district administrator boss is giving this kind of a report. I don't know how this happened. Like,
Let us see the report. Where is it?
my lord, last time, if your lordship remembers, the report was not with the government nor with me.
Ah.
It was with the other side.
It was with the private respondent.
Yes.
Okay, yes, something like that. Yes, private respondent. Where is the government report? Which the government lawyer does not have.
Report is against the petitioner.
I know, but I want to see, but only you have it. Even the government lawyers don't have it. You must be additional DC. Yes, take that. Oh, that's the government documents. You're for whom? Okay, you're PNRD. Who's the private respondent?
Where?
Oh, where is it? You had produced that document earlier. Where is it?
I have filed an affidavit. I filed my affidavit in
You filed an affidavit.
in the first case, not 4314.
Anyway.
My lord, the following were the
No,
findings.
wait. Okay, he's made a mistake. It should be 4293, is written 4393 in the report. WPC 4393 is said. Actually, it's 4293.
No. It's okay.
There are 3 cases, my lord.
No, it's okay. This is in respect of the earlier case.
Okay, respect to the other.
Earlier case, where all the 3 parties were together and that report was called. But it was not given, and because of that, we filed the subsequent case, my lord.
Okay, this case is for the
Yes.
subsequent case is for non-compliance with the
Yes.
order of the court.
Okay, the second round of litigation.
Yes. My lord, did you find the first finding?
Just a minute, just a minute. So where is the detailed report?
There are two, three landmarks, my lord. One is the executive.
I don't want that. I just want the DC report, that's all. Why are you giving me some other thing?
Everything is important, my lord. That is.
No. Not very important. I don't want to run around the bush like the heroine and heroine of a Hindi movie. You run around all the time. I don't have time.
For the report, my lord. Reports is against the petitioner, but
Whatever
it
it
is
is.
also admitted, my lord, the huge price difference is there.
No, I'm not on
It's
that.
not correct.
In connection, you show me, just
Yes.
give it to him, just
Okay.
because,
Can I give the report directly?
yes, give the report.
This is the report, Madam. This what, Madam, from in the findings are in the second page, Madam.
Hearing of complaint petition in connection with tender process of so and so, Said Ali, but you are not Said Ali, you are Abdul Barak.
No, all these three were together.
Who?
Said Ali is also there.
Abdul Barak is there.
Yes. All three are there, Madam.
In other cases.
In that first case.
In the
because
first case, all three are there.
all three were together. Madam, the findings are in the second page starts.
Yes,
Madam, the first finding.
yes, which one?
Madam, in
From
the
all the statements. From the statements
from
of
the
all the.
statements, yes. My lord, this is unheard of. I don't know how a status of a deputy,
But the process of dropping was started from 1 PM.
but before that
Box was there from 10 AM.
is something unheard of, my lord. My lord, if my friend from the other side, they can say there is a box placing and there is some kind of a process for 3 hours, I'll give up the cases.
And some, you'll give up what case?
All these cases, my lord.
You'll
I'll just
give-
walk away.
you'll
If they
give-
say,
You'll give up your profession.
no, these cases. Because it's unheard. I don't know how deputy commissioner has given this finding, my lord. They don't do anything. They just place the box. People come and drop the bid. That's all. What process is required for? That means ultimately from 10 to 2, instead of 4 hours, you are giving 1 hour. That means for manipulation. My lord,
I don't.
my lord, what happened in this case at 1
But
o'clock?
why couldn't you wait till 1 o'clock? You
No,
could
I
have
was
dropped it
there. I was there.
till 2 o'clock you were there.
Yes.
Then,
What happened, my lord? All of a sudden, 1 o'clock, the executive officer comes. He says, now you get in line. It is all planned. 20 people of the first category, they just formed the line immediately. There
Ah.
was no lining system ever.
then,
And ultimately, when the line comes, my lord, actual visual was that the person is coming. He's not dropping. He opens the envelope. He looks at his papers. He feels
so 2 minutes, so when 2 o'clock, when the clock struck 2, that time you were still in line and they
Yes,
had closed the
was
box.
in line.
And they,
I was making the call to the deputy commissioner. I was calling, those records are there.
okay. That's enough. Yes. Who are we waiting for?
Mr. Yarvia will appear
Oh, who?
Mr. Yarvia will appear for the private respondent.
Yeah. What has he got to say? Nothing. He's got no role to play. He's got his with regard to the dropping of the thing, that is the government has to say.
So far the report is.
Or you're hand in glove with them. You know more about the government machinery and the government working than the government lawyers. Is that your case?
There is a order, there is a inquiry, my lord, by the deputy commissioner, my lord, and in that inquiry, they were also called, my lord. And thereafter that inquiry, report was, my lord, come up. But that inquiry report is not, challenged by the, colleague, my lord.
Without my lord challenging that, my lord, how can they figure this matter?
We will take care of that.
After some time, my lord.
Yes, what have you got to say? You sit down.
My lord, I fairly submit, my lord. The report is against the petitioner. Because as per report, my lord, till 2 p.m., my lord, 1 p.m., as per instruction of deputy commissioner, some coupons were, my lord, there. And therefore only those people's bidders who have coupons, they are only allowed to drop, my lord. As per the-
You're supposed to take coupons.
As per instruction, rule, it's not there, my lord. But-
As per this report, is it there,
Yes,
coupons?
yes.
Where does it say?
My lord, my lord. The findings may I read, my lord, 3 paragraphs, my lord.
Yes.
The number 1, my lord, from the statement of all the above petitioners and respondents, it is clear that tender for the weekly bazaar of Besimari and Lalpul were called and opened on 6/6/23. It is also clear that time for dropping of tenders in the tender box was 10 a.m. But the process for dropping of tender was started from 1 p.m. As per the version of the petitioners, there was no tender box found in the office when they came to drop their tender papers, but the dependents have stated that the tender box were placed for dropping.
Who is this dependents?
Dependents are, my lord, in this case, my lord, in the first place, my lord, the BDO and the president,
Okay.
first place, my lord.
Hmm.
Yes, my lord. As per the version of the petitioners, that is, there was no tender box found in the office when they came to drop their tender papers, but the dependents have stated that the tender box were placed for dropping tender from 10 a.m. However, it is clear from the statement of both the parties and the dependents that the tender process started at 1 p.m. That is admitted, my lord. Now, as per the version of the petitioners, they were obstructed in dropping the tenders by some of the people engaged by the president and the Anchalik Panchayat of Besimari. But the respondent, that is both the BDO and the Anchalik Panchayat president, have stated that all were given the opportunity to participate in the tender process. Even extra time was given for submitting their tenders as per the direction of the Deputy Commissioner Darrell by issuing numbered coupons from the rear side who were standing in queue for submission of their tender papers. Altogether, 12 numbers of participants could submit their tender after the scheduled time of closing of tender papers. So this is the fact as per report, my lord. After the inquiry, this is the fact, my lord. This is against the petitioner, my lord. But, my lord, but that is also admitted that a huge difference of revenue is there. So I leave it to your lordship whether that can be sustained or not.
What was the reason for retendering?
Earlier, it was also less amount, my lord.
No. In the earlier tender,
My lord.
your private respondent had quoted 2 crores something.
My lord.
2 crores 7 lakhs, I think, something like that. But now, in the subsequent tender, he has been settled with that contract for around 28 lakhs.
My lord.
Why?
Huge difference, my lord.
Why? So my question is,
Have to go through the-
why was the earlier tender process cancelled?
No, it was not cancelled.
It was not
Okay,
cancelled. It
there
was
was-
earlier year, my lord.
Earlier a year.
Okay, earlier.
Yes.
Earlier. Okay. Earlier, yeah.
But the difference.
Something is
my lord,
fishy, my lord. That
my
is
lord,
correct.
difference in two.
I think maybe we should send this to the chief minister's vigilance
Yes, my lord.
thing also.
Or my lord, there is
To ensure that to have an inquiry into this.
What happened to this 1 crore rupees at least in respect of 3 markets? That will be the best.
Those officials should be taken to task.
Yes, ma'am.
Government doesn't have revenue right now. And these persons are
Yes, that is
looting the thing system. That's all I think. That's nothing else.
And there is also one provision, my lord.
Only one problem is this is a question of fact, no doubt.
Okay.
Now, one thing is very clear that
Sure.
from 10 to 2, the dropping of the thing should, if that was there, if they could have, if it was only for 1 hour, they should have given that 3 hours gap that could not be done. They should have given it here.
Yes, my
And the bottom
Extension.
half, extension of 3 hours should be given till from 1 to 4.
my lord.
That does not appear to have been done.
My lord, 1054 is saying, my lord.
What?
105, section 105, my lord. Of Assam Panchayat law.
Section 105 of
4.
104 of
1054 of the Assam Panchayat Act 1994. There is a provision, my lord.
just a
proviso,
minute,
my
just
My
let me turn that
My lord, my lord.
page,
I think we are holding different books, my lord.
same book.
Different book, my lord. Assam Panchayat Act
Assam
105.
Panchayat
Assam
Act
Panchayat Act
1994.
1994.
1054.
105.
Yes.
Rule 4, 105 sub rule 4. All settlements made under subsection 3 shall be subject to the confirmation of the Zilla Parishad. Now proviso, my lord, provided that in case of any dispute, the Anshalik Panchayat may refer such case to the government and the aggrieved party may appeal to the government whose decision in this regard shall be final. So lordship may refer this matter to the government in the Panchayat department, my lord. They can settle within a very stipulated time. Because we use revenue loss is there. And repeatedly government is saying, my lord, revenue is the main important,
This settlement
my lord.
is for which period?
Up to 30th June, my lord.
Up to 30th of June.
Start from with effect from it started from 1st July.
1st July.
It's a Panchayat year, my lord, 1st July to 30th June.
My lord, if your lordship gives me permission, can I give the difference of amount between last year and this year?
No need.
And your lordship wanted to see the previous year, my lord. That
Ah,
difference is also
You,
there.
you made a chart?
I made a chart. That can
Show
be
me the
given.
chart.
I think they have made a, they have collected.
I have the
that
whole
data.
record, my lord, but chart will help me.
So if you just see if the chart is as per the record. Just compare and contrast.
My lord, then your lordship has to mind repetition that paragraph and the new chart.
Huh?
Because I have got 2 years in my repetition itself. Your lordship has seen that
Two?
paragraph.
Two?
Last year and this year.
Huh.
And another one your lordship
Okay.
wanted the previous year. So this will be additional to that paragraph, my lord.
You just see the record. In the meantime, we let Mr.
And my lord, what my lord has suggested, I think CM vigilance will be the best, my lord. These persons, at least, my lord, this president and the video is the main person. They did not come till 10 o'clock. It was all planned. They came at about 1 and they put the box. And my lord, there is no process. Let my friend standing counsel say before this honorable court that there is a placing of box and there is a process for 3 hours. Never heard, my lord. Every year we are doing this kind of cases. What process is there after?
No,
placing
I
the
am
box?
not going to, you do the comparing, Mr. Counsel. You
Yes,
do
yes,
the,
yes, yes.
why you give it to me?
My lord,
I cannot do your
Also,
homework.
particular also.
My lord, I can give the amount, my lord. In
No, you all do it. Just give me. Yes, Mr. Goyal. Please don't take time. The issue is very small.
My lord, the issue is very small, my lord, and what my respected senior friend is submitting, my lord. As regards the tender time or the tender process, how it has been conducted, my lord, a ground level report inquiry had been conducted. And that report, my lord, has already read over by my learned friend, my lord. So from that report, it transpires that there is nothing illegalities on the part of the respondents while the tender process was carried on, my lord. So therefore, my lord, till that report, my lord, how this report is came into force, my lord, if my lord may be pleased to take up my writ petition number 4312.
No, the report has come. So what do you want to say?
Pursuant to a mandamus issued by this honorable court.
So report has come. Then what else?
Report has come and till date, my lord, that report is not under challenge. So that report is attained the finality, my lord. Until and
That report does it have to be under challenge?
No, my lord, that is the report pursuant to an order because, my lord, why, what I respectfully beg to submit, my lord. This is all the issues which has been raised by my learned friend, my lord, only in respect of the, my lord, decreasing of the bid value or the value which they have said that the loss had been incurred. My lord, it is the discretion or the nature of business what these markets are carried on, or it may vary to year, financial year of the panchayat, my lord. Now, my lord, this report, which has been prepared by the deputy commissioner pursuant to a mandamus issued by this honorable court, because, my lord, when the same issues has been, my lord, averred in the earlier round of writ petition, my lord, that this honorable court did not enter into that arena of the finding the disputed question of facts. Exactly, my lord, same thing is happening here also, my lord. Some disputed that we have been restrained from submitting our tender papers in the tender box. This type of disputed facts has been, my lord, narrated or pleaded in the petition also. So, my lord, in this forum, my lord, it will be difficult to adjudicate. That's why, my lord, this honorable court directed the authority, no more particularly the deputy commissioner, to conduct a ground level report. Now, that ground level report, there is nothing adverse, my lord, that as regards the tender process which had been carried out. So,
No,
therefore,
there is. The tenderers were supposed to be given 4 hours to deposit their bid. It has been reduced to 1 hour.
my lord. No, my lord, my lord, that is the why that situation. If my lord may be pleased to peruse the report just for a moment.
Yes, I know you're talking about that coupon system.
My lord.
Now
So,
that is something we do not know.
that is the
And
issue,
why
that
should,
is
why shouldn't, why, if they were given 4 hours earlier,
my lord.
why shouldn't it have been extended from 1 to 5 o'clock?
My lord, there is no any such guideline is there.
No,
under
but
the
then
Panchayat-
that you have got to
Panchayat
make,
Act
you have got
also.
to make, anyway, that
That is-
I understand your,
So
then,
therefore, my lord, the writ petition which has been, my lord, structured in such a manner that a roving inquiry should be conducted by my lordship to find out the disputed question of facts, which is not permissible, my lord.
no, we're not, we're just going to decide
lord.
whether, you see, the reason why we wanted the inquiry report
My lord.
was to find out whether he could have submitted his bid document
My lord.
between 10 and 2. Now,
My
as per the inquiry, it is clear that he could not submit it before 1 o'clock. That is clear.
That is his fault, my lord.
And
That is
we'll
his fault.
we'll see whose fault it is.
He did
That
not-
we will see.
My lord.
Leave that to the court.
No. My lord. this
Now,
is-
and then what is the other point that you want to take? That
No.
leave that aside. That's finished.
Other points, my lord, is that there is no illegalities or irregularities as per the Assam Panchayat Act, the procedure prescribed therein, my lord, that had been maintained by the authorities. Now, the differences of the, my lord, amount, which my learned friend is, my lord, agitating, my lord, is maybe due to the nature of business or the year, my lord, they are the experts, my lord, the authority which has been called for the tender bid, they are the experts, my lord, that in this year, what would be the business or what would be the amount. Now, my lord, in that expert field, my lord, that my learned friend cannot dictate that this should be the amount, my lord, that the last year so and so, so this year it should be also.
So everything is going, everything
My lord.
in the world is going upwards. Prices are going upwards.
No, my lord,
Only in Assam, in that particular
that
area,
that is not my.
it is going downward.
No,
That
no.
also by more than how much? More than what?
My-
2000%.
My lord, that is not my submission. What I respectfully beg to submit, my lord. My lord, nowadays the business is in the downfall, my lord. As per my,
Down, oh.
my lord.
Haven't you heard the central government saying that everything is going up better?
That is
Pushing towards.
Yes. Don't you read don't you read the newspapers?
Why?
Everything is shining now.
No, everything is going very well, my lord. That is, I have to admit, but my lord, in sometime in this type of panchayat markets, my lord, it is very, my lord, in the remote areas. Now, what?
So everything is going down.
Not very down, my lord, but business is not good, maybe, my lord, there.
Business
That's
not
why, my
good.
lord, that's why there is a difference in the, my lord, in the bid.
Anyway, those,
My lord.
so
Now,
those
now, my
things-
lord, may I pray, my lord, that why these differences in the bid value from the last year or for the present financial year which is going on? My lord, that is not, my lord, brought on record or nothing, affidavit has been filed. That this is the reason.
records are there.
No, records are there, my lord, but that reason that why it has been decreased from the so high rate to so less rate, that is not, my lord, filed in the form of an affidavit, my lord. Let them come up with an
Something is,
affidavit, my lord.
sometimes some things are too palpable
My lord, my
to
lord.
be ignored.
No, my lord, I,
When you have made
my, lord,
and a bid for 2 crores and above,
my lord, one
and
thing,
then the next year you make a bid for 28 lakhs
my lord.
and you're given,
No, my lord, what I respect.
doesn't seem to be logical.
My lord, what I respectfully beg to submit, my lord, is if my lord may be pleased to take
And
up the,
coupled with the submission made by the petitioners,
my lord.
it appears that there is something. There's no smoke without a fire.
No, my lord, that's something. Why that's something, my lord, that is not.
That is why we'll tell the CM's vigilance cell
My lord,
to inquire into this. Like you said, we will not do it. We'll tell them to do
my
it.
lord, my lord.
In the meantime, we'll stop this.
Then, my lord,
Then you
one
can
thing.
go to the DB in the meantime if you want. No problem.
No, my lord, it is the, my lord, we can advise the petitioners or the respondents only. my lord. It is up
Because
to
I
them.
think they're
My lord.
too palpable. Too palpable.
My lord, one thing is there, my lord, in page 26 of WPC 4.
Yes, where is the thing?
Records.
Where is your chart? Have you given? Are they comparing the rates?
No, it will be same because.
Okay. Yes, what do you want to show, Mr. Buyan?
My lord, settlement may not be disturbed, my lord.
We'll see.
My
Let me pass.
My lord.
My lord, if your lordship permits, can I give the 3 chart in respect of 3 cases? And on the tick mark, that is the person who got the. Interest, yeah, not available.
What is this item?
My lord, 9, 10 and 11.
9 to 11.
Okay, so there are 3 petitioners,
Yes, sir.
different markets.
Yes, sir.
Why is it all tagged together? They're different persons, different markets.
But in respect of the same Anchalik Panchayat.
So what? Okay. But it should not be tagged together. Anyway, I will take this item number 4293. Heard Mr. J. Abhijit, learned counsel for the petitioner. Also heard Mr. S. Datta for the PNRD department. And Ms. Udas for respondent number 2. Mr. A.R. Buyan,
My lord, for the,
learned counsel appears for the respondent number 8.
my lord. 11.
The petitioner's grievance is that he had not been able to submit his bid pursuant to the tender notice dated 11/4/2023 issued by the Bechi Marik Anchalik Panchayat for settlement of the Lalpur weekly cattle market, here and after referred to as the market, for the period 31/7/2023.
First 7.
Huh?
First 7.
First 7/2023 to 36/2024. Next paragraph. The petitioner's case is that the last date for submission.
My lord, may I have the permission?
Yes, yes.
Oblige.
The last date for submission of the last date of submission of the bids for the market in terms of the tender notice dated 11/4/2023 was which date?
6/6/2023, my lord.
6/6/23. Full stop. However, on the said date, the bid box, or what do you call it? Where is the document?
My lord, bit drop box it's called.
The bid drop box, the bid drop box,
Tender box.
the tender box. The tender box. Was put out for submitting the bids of the tenderers at 1 PM only, correct?
Yes, my lord.
And the last, and the bids was to be submitted till 2 PS. He submits that. The initial timing given for submission of bids was from 10 AM to
2 PM.
2 PM. Though the petitioner was in line to submit his bids, when the tender box was brought out from the office at 1 PM on 6/6/2023, comma, the dropping of the tender documents into the tender box was closed at 2 PM. Accordingly, the petitioner could not submit his tender document. Next paragraph. The petitioner's counsel submits that the petitioner had initially made a challenge. No, don't say that. You see, the bid was, the market was subsequently settled with the respondent number 8. Full stop. Then in that earlier writ, you made a challenge to the settlement order.
No, it was before the settlement.
Okay, cut that. Just say. As the petitioner could not submit his bid in the bid box. It bid/drop boxes, drop box, comma. The petitioner filed WPC 3689/2023. WPC 3689 of 2023 was disposed of, while order dated 28/6/2023, with the direction being issued to the Deputy Commissioner Darang to make a report with regard to the grievance of the petition. Then before filing this writ petition, was the report?
No. It came after 4 months
Okay, full stop.
instead of 15 days.
So full stop. Subsequent to the above events, the market was settled with the respondent number 7.
8.
With the respondent number 8 at his quoted rate of rupees.
My lord, 6,02,375. 602.
02, comma
6,02, 375.
375.
That is page 17. Paragraph 17, page 15.
The petitioner being aggrieved by the fact that the settlement had been made in favor of the respondent number 7, even though the order dated 28/6/2023 passed in WPC 3689 of 2023 had not been complied with, the petitioner has filed the present date petition. The petitioner has put to challenge the settlement of the market with the petition, with the respondent number 8 at the quoted rate of rupees 6,02, 375. As the said market had been settled with whom? With the same person?
No. with another person in the year 2022-23.
Had been settled for the year 22-23 with whom? Any name?
No, my lord.
With,
The
with another person
Yes.
at the quoted rate of
23, 23,
23,
23,
23,
323.
323. Full stop.
That is in page 15, my lord. Repetition page
No,
15.
that's not the full stop. He further submits that for the settlement of the market for the year 2022-2023, that for settlement of the market for the year 2022-2023, that is 1/7/2022 to 31, no, 36/2023, comma. The state respondents had any base price was fixed or what? Any minimum rate, what was fixed?
In the minimum fix, my lord,
The minimum rate fixed
5
was,
lakhs, 4,570.
no, I'm in that 2022-23
Same.
was 5, comma,
04,
04, comma,
570.
570. Full stop. Even for the settlement of the market for the year 2023-24, the state respondents had given the same minimum rate, same minimum base rate of 5, comma, so. Next. The
My lord, I had the desire to offer 33.40. My documents are there. No, because I had to buy the earnest money coupon with
Okay.
cash.
Ah.
I have bought that. That is the only thing to show that even I was a tenderer. Otherwise, why should I spend so much of money and get that earnest money document, my lord? For participation only. That is a different information.
Correct.
That will not.
no.
My lord, that was asked on.
Okay, that is submission.
Yes, my lord.
The petitioner counsel submits that the petitioner was intending to. No, the petitioner had quoted a rate of rupees
33,
33, comma,
40,
40, comma,
000.
000 for settlement of the market for the year 2023-2024. However, the said tender documents could not be submitted due to the reasons. Next paragraph. During the pendency of the case, the District Commissioner Dara has also given a report dated 10/8/2023, which basically states that though the bid tender/drop box had been brought had been placed outside the office to allow the tenderers to drop their tender papers, comma, at 10 a.m., comma, the same could only be done from 1 p.m. There was some videography done. Let us see that videograph. Okay.
As per the report, my lord, there were police were also there, but petitioner did not inform.
So, next one.
People were chased out of the boundary in front of police.
No, no, we do not know that. These are all, we do not. Give me the other petitions.
My lord, in this case, my lord, the 2021-22, the bid was 12,50,000.
Huh?
What my lord wanted. Previous year, in respect of this case, which
Okay.
my lord is dictating.
In 4293.
Yes.
Just give me the chart, you're not giving me the chart.
I've given the chart, my lord.
Again,
Yes, my lord. 3 charts. My lord, on top it will be written Lalpur Weekly Cattle Market.
Ah.
My lord, the person who is
Hmm.
hit, he has been settled.
next, the petitions council submits that
Or this can be set from the government record. So I have submitted it is in the
anyway,
record.
let me see. Who is this Moijun Uddin Ahmed,
2021 bidder.
21 bidder?
Yeah.
Then Komar Ali,
Yeah, all.
or
All.
21?
Yes. This is entire list is 21. This is the list of 21-22. Settlement amount
What
was,
about 22, 23? Where
that
is
is
that?
there in my petition.
Where?
Well, paragraph 15.
15.
Yes.
The petitioners council submits.
This already my lord has
That's
dictated.
the same market, huh?
This already my lord has dictated. This amount
Where?
already. Dictation is there.
No.
Yes. Settlement value.
This is what I said 22, 23. I'm not talking about 23, 24.
Oh.
Where is 22, 23?
That is in the paragraph 17, first line. Settlement value in 22, 23. 23, 23,
Where is 17?
paragraph 17, page
Ah.
15.
Yes.
Well, name of the market, your lordship got it.
Yes.
The first settlement value in 2022.
Okay. 23, 20. In favor of whom?
One Saddam Hussein.
Huh?
One Saddam Hussein.
Some spelling?
Saddam Hussein.
Spelling.
SADDAM.
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 Saddam Hussein. Iraq. And for Lalpur, and for this 21, 22, who got it? Yusuf Ali,
Yeah, this name is there. Where I see.
who quoted 26 lakhs.
No. The person who quoted 12,50,000.
Oh, boy, he's the lowest. He got it.
Yes. Others incomplete.
Okay, right. So the petitioner's council submits that the said market had been settled. This just a said market. I think we'll dispose of all these cases in one writ petition, one order. That becomes easier. Lalpur, we'll say Lalpur market, huh? Whatever I said here and after referred to as Lalpur market, huh? Whatever I said was settled in favor of one Saddam Hussein for the year 2022-23 at the rate of rupees 23,32 3. Huh? 23, 323, okay? And for the year 2021-22, it was settled at the rate of rupees 12,50,000. Next para. In respect of WPC number 4312/2023, which pertain to settlement of the
Pechimari weekly cattle market.
Bechimari weekly cattle market, hereinafter referred to as the cattle market. The respondent number 8
Paragraph 17 again, my lord.
has been settled with the market. No, the cattle market has been settled with the respondent number 8 at his quoted rate
2,99,000.
of rupees 2,99,999. While the said cattle market had been settled in the year for the year 2022-2023 for rupees 22,222 in favor of the cattle market, Bechimari cattle market, for 22-23. Huh?
Lal Fakir.
Spelling
LAL
LAL
AKIR.
FAKR, Lal Fakir. He further submits that the said cattle market was settled with Moijuddin, Moijuddin Ahmed for the year 2021-2022 at the rate of rupees 12,50,000.
No, my lord, I think your lordship is.
Oh, no, this is Lalpur, sorry,
Yes.
sorry. Sorry. No, sir. With not Moijuddin, sorry, it is with
11 lakhs. 21, 22, 11 lakhs.
Pechimari weekly cattle market.
it is with whom? With
Abdul Karim.
no, there is no Abdul Qadir. Abdul Salam is there. With one Omar Ali. Or what? With whom? Jalaluddin is there. Just see. For the year 2021, with whom?
It's my notes is saying Abdul Karim.
How much?
11 lakhs.
That can be taken.
We sell 11 lakhs with one Abdul Karim. Huh?
This is the minus of the.
Huh? For the year 2021.
No, 21, 22.
21.
For the year 2021, 22. Next, in the case of, in WPC number 4309 of 2023, the settlement of the Bechimari daily vegetable market has been made with, wait, before that, in the state respondents had fixed the base price of the cattle market at the rate of rupees for 2023-24.
That earlier Abdul Karim for vegetable, basically vegetable. Sorry, because it is identical name.
What about for the cattle market? What?
That earlier my friend of that one.
Cattle market is there 5 names. Yusuf Ali is there, Komar Ali is there, Moinuddin Ahmed is there.
My lord, I think one I ticked mark, that is the person who got the
The
settlement.
one you tick mark is Moinuddin Ahmed.
He,
Yeah, please check from the records. I'm not going to say.
and the government value was 2,46,
2,46, the base price
235,
was rupees 2,46,
235.
235 for the year 2023-24. And for the year 2022-23, it was how much?
Base price. Base price same. Remains.
No, 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 no. We have to check. We are not going to do this like that. Let's not rush things.
Could be there in my chart, the base price.
You don't have a copy.
No,
Why?
the only copy I could take out.
You're willing to pay 33 lakhs for this and that. You're not willing to pay 2 rupees for this one.
46,235.
Is that correct? 2 lakhs? What is the base price? What? Two 246, 235. Okay. 23, 24. And for 22, 23, what is the base price?
Same.
Acha, for same price, huh? For the base price for 2022, 23, huh? Then in the case of in WPC number 4309/2022, which pertains to settlement of the Bechimari weekly cattle market.
I think it's
No, Bechimari weekly vegetable market.
daily vegetable market.
Daily.
Yes.
Bechimari daily vegetable market. The market has been settled with the respondent number 8. Huh?
The earlier name I have submitted.
No, for this now, for now. As we settled with the respondent number 8 for the year 2000, for the year 2023-24 at the quoted rate of
8,
8,
99,
99,
then 999.
999. Where is that other matter I was doing? There was the 2 crores and then it went down to 28 lakhs. Not you.
No, not me.
Oh,
that that is paragraph 19.
There's another case. For out there, it was quoted for 2 crores something in the year before. And the next year it was settled for 28 lakhs.
And I think that is also from the district only. Same district.
So I get mixed up.
Right.
So many similar cases. Yes. So
It is given in paragraph 19. Page 17. Our settlement value, your lordship got it.
8, 99, 999.
Then the last year was
For the settlement of the market for the year 2023, 22-23, which was done in favor of Abul Karim, Abul, ABUL, Abdul or Abul? How it is Abul, ABUL, huh? Abul Karim for rupees 11 lakhs.
no. Or 22, 23, it is 64 lakhs. It is-
This is 21, 22.
Yeah, yes.
Sorry. It is 64,03, 200. With whom? In 22, 23?
One Abdul Samad.
No, let him check.
Bill is 64 lakhs, 320.
3,200. Abdul Samad. the same market was settled for the year 2021-22 with one Abul Karim for rupees 11 lakhs.
And for the 21-22, my lord, for the Posu Hut, my lord, the cattle market, the Simari, that was one.
Moijuddin Ahmed.
Umar Ali.
Huh?
Umar Ali. In the Besimari weekly
Cattle market.
cattle market, my lord. I was wrong.
Umar Ali.
At that time. Yes.
It's Komar Ali. Oh, okay. So instead of that Moijuddin Ahmed, no? It should be Komar Ali. K-O-M-O-R.
Umar.
Komar. Huh? Komar Ali.
The value of 3,50,100.
For which year?
21-20.
Out here it is saying 14 lakhs.
But record. As per record, I'm saying.
Okay, 3 lakhs. 3 comma
3,50,100.
3,50,100.
That is the earlier
That
repetition.
is for 21-22.
That is the earlier repetition.
For 20.
For the cattle market.
I know.
Because I had wrongly submitted, that is why I.
But how come you gave such a wrong figure here?
Umar Ali.
Komar Ali.
I have given.
He has given 14 lakhs.
No, I think the tick mark one, my lord.
Tick mark one is Moijuddin Ahmed. This is for the cattle market.
Besimari cattle market.
No, this, oh, sorry, this is Lalpur. Sorry.
Lalpur.
Out here in that cattle market, it will be Omar Ali, 3,50,100. Huh? That is why I need for facts and figures. I need everyone. The base price fixed by the state respondents for the Bechimari daily vegetable market for the year 2023-24 and 22-23 was 7 lakhs 25,000 395. Next paragraph. The petitioner's counsel submits
Malin, I think that figure may be changed, Malin. 7,97,000,
7 lakhs
97,000,
97,934.
934.
Is it correct?
Serial number 7.
Government.
He's-
Common value, huh? I'm saying it from the tender paper itself. It is
The cooperative statement.
there in page 30.
No, it has to be as per the tender. Oh, well, that second figure, huh? You got it, no? Just say once more, 7 lakhs,
7,97,
7,97,
934.
934, huh? Yes, instead of that 7.
My lord, that was enhanced, my lord, for this year. Because in the earlier 2 years, they were.
Okay, that is for 20, then, no, that, what do we enhance for this year? For 23-24, it was,
22, that is here.
Ah.
22-23, 7,25,390.
okay, then we have, for 22-23, it will be 7, 0,
257,253.
okay,
And
So-
for the year 21-22, that was 6,599.
yes, 7, and for 21-22, it was 6,
6,59, 456.
5, okay. So for the other markets, you have not given me 21-22. For all, from 21-22, it's all same.
Because it's a bigger market.
Okay. So we'd have to do it, Anupam, for those other 2 repetitions, the base price for all the 3 years will be the same. Correct? No, this one is separate. Out here, the base price is different. For 23-24 is different, 22-23 is different. And but in those other 2 repetitions, the base price is the same for all the 3 years. 21-22, 22-23, 23-20. That's all. Huh? Yes, correct, correct. We'll have to make a chart. of it. Yes, so what is the submission now? That, okay. Now wait. Now in this, in 4309, how much were you willing to give?
My lord, that is in para 19, I myself said, my lord, 78 lakhs.
Okay, in this, 403, huh? 4309. The petitioner case is that his bid, which he could not submit, had quoted a rate of rupees 78,
91
91
999.
999 for the vegetable market,
Yes, my lord.
for the vegetable. And for the cattle market, Bechimari cattle market, how much? Is that 4312, huh? 4312, how much did you quote?
4312, my lord, that is in paragraph 17.
Hmm.
23,
23,
33,
33,
333.
333.
And my lord, in 4293,
Yes, I think we have already taken that.
yes.
The petitioner's counsel submits that due to the petitioner not being able to submit his tender documents. No, the tenderers not being, the petitioners not being able to submit the tender documents. The no, due to the reasons stated aforesaid, the government has suffered a huge loss. Accordingly, the settlement orders issued by the respondent number 4 in favor of the respondent number 8 in all the writ petitions should be set aside. And direct the respondents to go for a fresh tender.
And also to cause an inquiry, my lord, that is there in my prayer.
Yes, sir. Further, the respondent should be directed to cause an inquiry into the matter. Yes, sir. That's all.
Yes, sir.
So you cannot be given anything.
No, my lord, I did not get the, first of all, I could not even submit. How can I ask for anything? Only for fresh tender, but they have already enjoyed for 9 months almost. And my lord, this is the main persons behind this, the officials of the Anchalik, that is the video.
So supposing we send it to the Anchalik, no point, huh?
My lord, what-
1054.
well, what I would suggest, my lord, if your lordship permits, my lord, what my lord suggested, it should be the CM vigilance, my lord.
No, but since the provision is there. Anchalik Panchayat may refer such case to the government.
Anchalik Panchayat, over here, my lord is sending. If my lord has found something palpably wrong, where almost 1 crore rupees has been siphoned away. It is not siphoned.
No, it's not 1 crore.
Yes, my lord. My lord, 2022-23, it is all these three markets, 1 crore 9 lakhs 48,000. And last year, this year is only 18 lakhs 2,000.
Just a minute. How much was it? 1,
1,
comma,
09,
09,
48,
48, comma,
745.
745 and
In respect of all these three
3
markets.
and,
And this year, what they have got, 18,
18, comma,
02,
02,
373.
37. 90 lakhs.
91 lakh plus.
90 lakhs.
In only three market, my lord. These are before my lord. There are 17 markets. And one my lord has come across from 2 crores to 28.
They'll be enjoying a better Holi, I guess.
My lord, I think
No,
persons doing it is okay. But where the system is supporting, then other persons are being dealt in such a different manner. Means it's like you are not even allowed to participate.
So we send it to whom?
What my lord has suggested, it has come up from my lord's mouth. I'll
Principal
pray,
Secretary. Principal Secretary to?
my lord, I'll pray for CM vigilance, my lord. At least something will come out. I'm sure, my lord. It's like indirectly like CBI inquiry. And they don't leave anybody. If government found anything, my lord, they can refer.
They can refer the matter, yes. Let us see. Let them do, let it go by the procedure. Since there is a statutory provision, we'll refer it to the government.
And my lord, if I could make out a case, my lord, only thing the palpably something is wrong.
There's something wrong.
Then the Jilla Parishad
No,
will-
we can send it to the government and also they can also intimate. We can give some indication that they should maybe approach the CM.
Yes, yes, yes. And my lord, in the meantime, this.
So that he will not have any competition in the next tender process. Huh?
My lord, settlement.
That is why you are so excited about this.
No, actually,
So
because
that your main rival will go.
my lord, this time it is such a planned manner, I couldn't do anything.
He outfoxed you.
No, the system outfoxed me, my lord.
Huh?
There is such a plan that will come at one,
So
we'll say line.
the two.
Bidders are clear, my lord. Like I
Huh?
said, half of the bidders are clear.
No, he's cleaner than the others.
My lord, if you, what I will pray, my lord, this settlement should go because this cannot survive. Because more than at least, as my lord said, more than 100 times the Jilla Parishad will be able to give it to the government for remaining 3 months.
Okay.
In this regard, my lord, so for the settlement is concerned, my lord, all the settlement holder are offering value more than the minimum bid value, my lord. So if the, can I submit my, nothing, my lord.
He's trying to, disturb you and you're falling for it.
So if the government
You-
think about the falling of revenue, my lord, they give a-
Ignore him. Huh.
if the government is thinking about falling of revenue, they should increase the bid value, my lord. What is the fault of this settlement holder? They offer bid value and they are coming highest bidder, my lord. Therefore, the market was settled in their name, my lord. So what is their fault, my lord?
I don't know.
So at this stage, my lord, at this stage, my lord, the settlement may not be, my lord, interfere with, my lord, and the matter may be referred to the government, and within a time period that may be, my lord, government may be look after, my lord, within 15 days or 20 days, my lord.
So even you are advocating that it should be sent to the government. Yes, submission.
If your lordship think it fit, my
No,
lord.
no, what is your prayer? What is your prayer?
My prayer is, my lord, an inquiry has been conducted. In the inquiry,
So it should be
clear that,
dismissed.
it is clear that coupon has been given and all the persons who got the coupons, they submitted their tenders. And thereafter, my learned senior colleague has said that they are not allowed to put their tender paper to the tender box. And the inquiry report says there is no such indications, my lord. So at this is that
I am, my submission is that, my lord, there is nothing happen as claimed that they were barred, my lord. And if they have any agree, then they should challenge that report, my lord. That was not before this honorable court. That report was not challenged before this honorable court. That is my submission now. And even then, if your lordship think, then it could be sent to the government, then your lordship may please, my lord, and so far the settlement is concerned, that may not be disturbed, and within a time period, the government may be directed to look after the whole matter, my lord. If your lordship think it, that will be the.
Okay.
response.
That- Okay, what have I said now? The petitioner's counsel submits what? Just read. Petitioner's counsel submits. Before that, you also say that he further submits that the entire system has been manipulated by the petitioner, by the respondent number 8, in connivance with the government officials, in connivance with the concerned officials
Officials of the Anchalik Panchayat.
of the Anchalik Panchayat, which requires to be unearthed and they should be acted upon. And that the law should be set upon them as per law. Full stop. Next, Mr. A.R. Buyan, the learned counsel for the private respondent number 8, on the other hand, submits that the setting of the base price is not the is the responsibility of the Anchalik Panchayat, and the respondent number 8 has got no role to play in the same. He further submits that there is nothing wrong done by the respondent number 8, as he is only a tenderer who had submitted his bid on time. He submits that the petitioner not having submitted his bid on time, the petitioner does not have any locus standi to file the present writ petition. He further submits that now your senior will say that I did not say all this, then what happened? Suppose now whatever I am recording, supposing your senior then says later on, I did not say all this before the court, then what happened?
So further, my lord,
Yes, or whatever you are submitting right now. With regard to 1054.
105, my submission is that even if lordship think it fit to send, then, my lord.
That's what I'm recording that. He further submits that. He further submits that if this court is of the view that
My lord.
the matter should,
No, my lord.
No,
Because I
then
am
don't
the-
make
no, 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 no,
submissions.
No, 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 I am the conducting counsel, my lord, in this case.
Th-
And
th-
I am
So
guessing that, he
then
will not oppose it,
take
my
your
lord.
sheet then. I will not do.
He will not oppose it, my lord. He will not oppose my submission, my lord.
He will not oppose. So, okay, he submits that even if this court is of the view that the dispute, the issue raised by the petitioner is to be decided by the government in terms of section 105 of the Assam Panchayat Act, 1994, hereinafter referred to as the 1994 Act, the tenders that have been, no, the markets that have been settled with the petition, with the respondent number 8 should not be interfered with. Further, the inquiry to be made in terms of section 1054 of the 1994 Act should be concluded within a very short period of time. That's all. Full stop. Next, Mr. Mr. S. Datta, learned counsel for the PNRD, and Ms. U. Das for the respondent number 2. Submit that in terms of the report made by the district commissioner relating to the dropping off the tender papers by the tenderers, it is quite apparent that the time limit for submitting tenders had been shortened from 10 to 2 to 1 to 2. Full stop. However, the report further states that for those still in line, for those tenderers still in line, who are waiting to drop their tender papers in the tender box, they were given coupons to enable them to drop their tender papers even beyond 2 p.m. Is it? Even beyond 2 p.m. On 6, what? On 6/6/2023. They have a submit that what? They have a submit that
The fees are also concerned, my lord, revenue, my lord. The state revenue is also important.
they have a submit that the issue raised by the petitioner needs an inquiry in view of the fact that the settlement of the market had been done at a considerably lower rate than the previous years. That's all. He accordingly submits that there being an alternative remedy for settling the issue raised by the petitioner in terms of section 1054 of the 1994 Act, the present issue should be referred to the principal, what, to the principal secretary to the government of Assam, PNRD, for disposal, for its decision. That's all. So stop. I have heard the alert causes for the parties. So stop. To make the picture more clear, it is felt that a chart regarding the settlement of the three markets for the 3 years at the rates accepted by the Anchalik Panchayat should be made, should be made. First up. No, then you make the chart. Next paragraph. A perusal of the above chart clearly goes to show that the Anchalik Panchayat has settled the market at a considerably lower rate than the previous years. The three markets had been settled for the year 2022-23 at a total value of rupees, how much? Calculate 2022-23.
22-23, 1,09,
1,09,
48,
48, 745.
745.
Good, sir. However, for the year in question, that is 2023-24, the three markets have been settled
18,
at the rate of rupees, at a total rate of, for a total amount of rupees 18,02,373. Thus entailing a loss of rupees 90, what?
more than 90 lakhs.
Just entailing a loss of approximately 90 lakhs.
Yes.
The above disparity in the settlement of the above disparity in rates. No, the huge disparity in rates for settlement of the market is very palpable. No, does not seem to be palpably, does not seem to be, no, the huge disparity in rates. Please leave that, I'll continue later. Let me see. Either this way or this way, it'll go. Just say hearing concluded, judgment reserved.
But if your lordship wants to put under in the petitioner's intention in respect of three markets amounts to 1,35, because this is on record.
We'll
leave it to
see,
your
we'll
lordship.
see, we'll see, we'll see that. I don't know.
But only one thing, my lord, my one denial is there, your lordship may record, my lord, that regarding the coupon system in our entire writ petition, there was no coupon system and at exactly 2 o'clock they closed the box. That is my submission, my lord.
Okay. Just put one more paragraph to just say. The report of the deputy commissioner is to the following effect. Then, full stop. However, the petitioner's counsel has vehemently denied that any coupon system was followed for submission of the tender document on the said date. Okay. So, Shelby,
Deeply obliged, my lord.
actually no hurry now because for you cannot get anything now. You cannot get the tender anyway.
No, suppose the retendering is done, I'll again attempt, my lord.
Retender will be from. The
Actually, my
settlement will
lord,
be only
No,
from.
my lord, your
the-
lordship is correct, my lord. The period has gone actually.
Period
9
gone,
months have
finished.
gone.
Ocean. Acha, take this. Huh? How does it look? What is this?
Well, initially, my lord, request for proposal was issued on 6/1/24 for my lord, issuance of the IFL license in the Lakhimpur district, different shops, my lord. Pursuant to that, my lord, which were received. But in few my lord, shops, including the present petitioner shop, my lord, both the petitioner and the respondent number.
Did not have there were,
Lordship, my lord.
so on the same grounds, while one was disqualified, the other ones was selected, granted the license.
That was the first my lord, technical evaluation where we have been rejected. Then rebid was called for.
Rebid was called for.
Rebid was called for. But you will find, my lord, the ground of rejection in the first one is at page 68.
Page 68.
Page 68. Is the my lord, technical evaluation committee, my lord, findings, my lord, page 68.
Yes.
Serial number 4 is the my lord, writ petitioner and 5 is the my lord, respondent number 5. Now the extreme my lord, right hand side, my deficiency was a highway distance 22.86
This
meter.
is with regard to the first,
First
then,
one.
how
Then-
does this is not relevant.
Lordship, my lord. Then lordship may come to my lord, page 71, my lord, the next, my lord, the rebid was issued, my lord.
Okay, the notice NIEBIT,
Lordship.
that is dated
That is, the present one is dated 23/2/2024.
23 to 24.
Lordship.
Yes.
And my lord, here it says for details, please refer to the previous bid documents and follow the revised timelines as given. And the dates are given, then the documents to be given is at page 72.
Yes.
Scan copy of the duly filled application, etc. My lord, here your lordship will find only serial number 17. Original bid documents duly signed and stamped on each page. That is to be submitted, my lord, physically subsequently. Now, my lord, the second technical evaluation, my lord, committee said, your lordship will find at page 73. I have been declared disqualified. Respondent number 5 has been said to be qualified. And the evaluation at page 76.
Yes.
Mine is serial number 3 and respondent number 5 is serial number 4. Affidavit regarding no excise shop license having previously submitted. But they mean that
Page 76.
page 76 against.
Affidavit regarding no excise shop license having, yes,
One affidavit has to be filed that I am not owner of any other license shop. So
Yeah.
that has to buy an
Yeah.
affidavit has to given. So it is said previously submitted. This document I had uploaded in the previous.
affidavit regarding no excise shop having previously.
After the,
What does it mean?
this same affidavit I had uploaded in the previous, the initial.
Okay, okay.
Lordship.
The
There's
same affidavit that you uploaded earlier,
Earlier,
in the earlier page, you have uploaded again here.
again,
Yes,
there's no bar as such.
there's no bar.
There's no bar.
There's no bar.
The second ground is that a signature bidder is not found in some uploaded documents within, which is mandatory as per guidelines. There's Lordship has seen the documents, except the original bid documents. There is no other document.
No, no, let us see.
Lordship. Page 72. Oh, sorry, page 70.
Page 72.
Yes, 72.
Original bid document duly signed and stamped on each page. On each page.
Is only in serial number 17.
So original bid document has
Yes,
to be duly signed.
yes.
So-
So there is no, there's no dispute that I did not sign in the original, but they say, some of the documents, which I have uploaded there, I did not put the signature.
So you did not sign in all the documents.
Lordship, it is not the original one.
Okay.
Uploaded one.
Uploaded one is not original.
No, original has to be submitted, separately, physical copies. Now, so far, the respondent number 5 also suffers from the same defect. If at all this is judged as a defect, the respondent number 5 also.
And
suffers
the same with regard to the
Yes.
same issue,
Yes,
with
same
regard to affidavit and with regard to the signature.
signature. Not only that-
How do you prove that?
not only that, his application was also, the earlier one which he had submitted. I have annexed the documents your lordship will find. At page 80 is my document. Page 80 is the affidavit, that I had submitted. It is dated, 2nd February 2024. Date your lordship will find at page 82. Now the last NIB was issued on 23/2/2024. This is 2nd February, 2024.
Yes.
Then his affidavit is.
You have not put the year.
Here is not there,
But in page 80.
but page 80 it is there, down seal,
Okay, anyway, that is not the ground anyway.
That is not the ground. So far as his affidavit is concerned, it is at page 83. Your lordship will find, his date is 31/2024. Your lordship will find at page 85. Same, Then not only that, this, 3 years, the IT return to be submitted, that needs to be,
That is not an issue.
yes,
No, no, that is a different thing. Now, tell me about this other one. Signature.
signature. So far as his defect were concerned, I have objected to, that document, of course, not having signature is not there, on 3 count, I had objected after the
No,
technical.
no, okay,
evaluation.
okay, then let me ask. Yes, Mr. Counsel, one thing. Affidavit is to have a case. Now, with regard to the second ground, what have you got to say?
Page 78, my lord, admission of the petitioner himself.
Page 78.
78, my lord, after rejection, he approaches this bidding committee. At the bottom portion, my lord will see the signature of the bidder is not found in some upload. I beg to state that I have not put my signature in some documents.
Yes.
And that apart, my lord, this is also a case wherein, my lord, the Ronak International comes into full play, my lord. First, assailing the others settlement, he has to show that he has a right. that
No,
he
no,
qualifies
no,
for
but
that.
he's put that
And in
challenge.
the meantime, my lords, the private respondent, the LOI has been issued. He has deposited the deposit at white 15-3, my lords.
License has not been issued.
License is issued, my lord. He has deposited.
License has not. been
License is not issued, my lord, because see,
Yes.
model code of conduct, that is the issue.
No, but it's a approval is
Yes.
required, etc. minutes.
And my lord, let's kindly see the one, okay, if I also concede the affidavit part, what about the other part, my lord? He has himself admitted that he had not given any document. He had not signed his documents properly, my lords. Himself admitted, my lord.
Please tell me one thing,
My lord.
the requirement in the NIT is that only the original documents are to be signed.
No. What is it?
Yeah. Cross 70.
No, my lord, that is also, I'll come to my petition, my lord. There is a clause at page 37, which is blood,
Page 37.
page 37. Versus part, I don't know, but my page, the 7.4 and 7.7.1, it ends. However, it is blurred out there. But there is a 7.6, which says all documents submitted by the bidder shall be signed by the author signature and also be affixed by the bidder's entity stamp. The registered owner, registered bidder shall be agreed.
How come this portion is page
Somehow it is,
37?
in my page also same.
Yes,
but-
madam.
but
I have
yeah,
this
no,
original, my
But,
lords.
Lordship, can you see? So far the second bid is concerned, what he is showing, it is with regard to the first bid. The second bit, the documents which are to be annexed, my lord, that is given in page 72.
No, I'm not on that. I'm on the question of you signing all the documents.
In case, my lord, I have the private respondents documents and also the documents of the petitioners, my lord. My lord can compare, my lords. Signs are not there. Had it been a case, my lord, they could have cared to annex their documents, my lords. They have not annexed. They have not even cared to annex also. Had been the case, my lords. Had been the case, my lord, they should have annexed it, my lords, their documents. They see, I have signed all this.
In my representation, I said I have not signed all the
He has
documents.
admitted he has not signed.
So you have
That's right.
admitted,
No, but I said, but the originals are submitted, my lord, and as per the clause, my lord, the originals are to be my lord, signed. The clause
these
that,
cases, the uploaded documents are not original documents.
Then he's
That is his case.
original in the sense, my lord, the physical, my lord, physical, what they mean, everyone has to submit the
So-
original.
So your uploaded documents are original documents or not?
But these are scan copy, my lord.
Scan copy, so it's not an original document,
Scan
according
copy,
to you.
everyone has to submit the scan copy of the original.
So the
document.
scan copies are not original documents.
Scan copy of the originals.
Scan copy of the original.
Originals. And the
So
originals.
no signature is required in the scan copies.
No, my lord. The originals physically has to be submitted, there the signature has to be there. That was the clause 17.
He's saying that the scan copies are not original documents, so the signatures are not required on the scan copies.
How can it be, my lords?
I don't know, that is
The
his say.
veracity, my lord, the instant veracity of that documents are a doubt if it's not signed or scanned when you upload also. In case, my lord, he can
No,
also. present
so
the-
when you file a writ petition here in the High Court, please do not sign your documents, your writ petitions. If it's going to be scanned, only the original which you give hard copy has to be signed, is it?
Well, that would mean, my lord, the with signature of the original, the scan copy. My lord, by
As
the,
a-
by the,
Look, I don't know, I'm asking
Even,
you.
my lord, there's a clause which says that document which you upload has to be digitally also signed. It's page 40.
Page 40.
Page 40. 10.4.3.
Just a minute. Just a minute. Ten point 4.3. The e-bid document shall be digitally signed at the time of uploading by the authorized signatory of the bidder.
But that is not disputed, my lord. That is not disputed here, my lord. What they said all.
Out here it says that you see, out here it says the e-bid document shall be digitally signed. It does not say that this normal signature is required.
My lord, whatever, digital sign is there. My lord, he has to make out a case that, okay, I have not physically signed, but I have digitally signed. That is also not coming out, my lord. He said, I have uploaded that his letter is self-explanatory, my lord. It says, I have not signed a few documents.
Because it is not required, originally submitted. If further I have said it in therein also. Sir.
And to that point, my lord, sir, the final allows.
And further down in the representation, you'll also be fine.
No, this, you see, because out here. 10.4.3 talks of the e-bid document shall be digitally signed. It does not talk about this normal signature.
Normal signature.
So at the time of uploading, now the thing is that whether it was digitally signed or not, that is not the reason for disqualifying his bid. So you can't take that up now.
I'm just not taking it up. It was otherwise. Otherwise also, well, since he's himself admitted that I have not uploaded my documents with proper signature. Now,
No, the question is, those documents which are supposed to be uploaded, have they to be signed?
they have to be signed, my lord.
For this next NIB, what documents to be submitted is at page 72, not the one which he is referring to. That is with regard to the original RFP. The initial RFP that was issued. Now with the second one at page 72.
Second row.
Yes, page 72, what?
My lord will see what
These
the
are the
confusion is trying
documents.
to create. He says the clause I'm relying is a part of the previous bid.
Previous bid and this bid,
No, my
same
lord,
thing.
that I'll come to, my lord. At page 71, my lord will see. For details, please refer to the previous bid document.
Page 70?
71, my lord.
Yes,
It says,
yes,
refer to the previous bid
it's
document.
the same thing. It has to be applied here
So
also.
that argument goes, my lord.
Yes, that argument goes. So those, you see, all the conditions that were there, they'll apply here also.
Yes, that
Right.
come. Yes.
Then,
Now, my lord, so far as their rejection is just some of the documents my lord, I did not sign, my lord. So it is not there, my lord, in this particular, my lord, 72, my lord, page 72, that it is required, my lord. It is, in the original one, it is required that they digitally sign. The ground of rejection is not the digitally signed. And my lord, after the.
but that is not your case anyway. Now you have made this case.
No,
Now, where is
because-
your,
no, but
let us see your representation again at page
78, my lord.
78.
78. The second last paragraph, with regard to first ground that affidavit regarding no exercise of license having previously submitted, I beg to state that said affidavit was sworn on 2/2/24 and the same was submitted earlier along with the tender and later on the same was returned to me. Later on when the tender was issued on again on 23/2/2000.
What about this 7.6?
Yes, my lord. Next.
7.6.
Next is with regard.
7.7. 7.7 is important. Which is unreadable in your petition.
Yes.
What would it?
I think this decides the fate of your case. 7.7.
Procedure to apply.
No, yes, procedure to apply,
Procedure to apply.
7.7.
All pages of documents.
Shall be required to sign, scan and upload all pages of his bid document. Sign, you have to first sign and then scan.
For a moment, my lord, if this is, my lord, kept for a moment, my lord, the other grounds what I am assailing is that his income tax return for the last
Mr.
3
Counsel, that is, once you have to show that you are eligible. Now, once you have crossed the first hurdle, saying that your disqualification was wrong
That
and
is-
has to be overturned,
that is-
then only you can challenge.
Look, only matter if they have waived those conditions in respect of the others, that has to be given to me. Now they have to satisfy that the respondent number 5 has submitted the
No,
document.
no, no,
No,
no.
with all signature, because I have.
I am not gonna.
Logically, see page 79, serial number 2.
Sorry. I have already passed orders.
Yes, I have.
I've already passed orders. Otherwise, I'm not going to change my view.
That part, madam, what I am saying.
I know what you are saying is that though you might not have qualified, the allotment of the contract or whatever the license to that other person is wrong because he did not do this.
No, not exactly this. What I am submitting, while the authority relaxes a particular condition in respect of the particular tenderer, same has to be given.
To others. Correct.
That is the.
Correct.
So therefore, my lord, 79, my lord, I have said in serial number 2,
Ha,
that all documents are not signed by him, but if private respondent number 5.
okay.
So he has to satisfy that all the documents are signed by
Okay,
him.
okay.
That is my-
Yes, okay, yes. So he says, you see, there are two grounds. One is that affidavit part, he seems he has got a point. The second part is that, okay, he did not sign all the documents as is required. However, that other person, he also did not sign all the documents as was required.
That is my humble understanding. That is his allegation. First, he has to establish a right that coming to read court, he has a right. Who gets what?
No,
that's a
no,
different issue, my lord.
but then what he's saying is that you have to apply the law, the same issue equally. It is, if he was harping on some other point, then okay.
Correct.
But you cannot say that you are holding a red pen, you go out, you are holding the same similar red pen, you stay.
No, that is not the case, my lords. That is not.
That is what he's saying.
Not to-
Page-
But the representation of-
I have a original documents. My lord, can pay
Okay,
us.
just see,
That's
just see
not-
that.
that's not-
Did he sign all the
Yes,
documents?
all signed, my lord, all signed.
Oh,
all
then it's enough.
Yes.
And even my lordship has one recent, my lord, 7/3/24, similar issue came up. And my lord, I have a Supreme Court judgment of 2023 judges bench, my lord.
Tata Motors,
my lord,
Tata Motors. I mean,
48 and 49 page paragraph.
relies upon Ronak. Mr. R. Mazumdar is smiling, I don't know. Is this, you have to overcome this hurdle.
Let's just take up another, I'll just check up these documents and I'll.
No, he is not entitled to take these documents here, my lords.
I'm checking,
Yes.
I'm checking.
He is not entitled. Lordship may be.
No, I'm checking it,
Yes, my
that's
lord,
enough.
my lord, exam.
Yes, that is enough, madam. Want to save the time of the court, madam.
This is Sita Nanda Hazarika.
Hazarika. That's what I was. Photo taken by the.
One page doesn't seem to have a signature. Verified.
Taking appropriation.
Wait, huh? No, it has. It has. There was no
This,
seal, that's why I missed.
Well, this tenancy agreement. It doesn't have the signature. Tenancy agreement that is submitted by.
Just let me see. I'll see all the pages, don't worry.
Gotcha.
Wait, you get actually probably.
Into the three-quarter line.
We are wasting time,
Yes.
I think what tenancy agreement?
Tenancy agreement, dated 22/1/24.
Tenancy kan roka athir bolo.
You just turn to that tenancy agreement, just show it to them, and just let them show it. Okay, right.
Okay.
Heard. What's this?
Where is it? Sign for that. Okay. Sign as it.
Then affidavit of the landlord.
This is a new case. Earlier some orders have been passed, no? Huh? This is the first time it's come up.
First time, most of it.
Oh, first time it's come up. Okay, okay.
Affidavit of the landlord is also not signed.
Huh?
Affidavit of the landlord is also not signed.
Affidavit of landlord not signed?
Right.
I don't know.
Because he has offered a tenant
Mm.
premises.
Heard Mr. P.J. Saikya, learned senior counsel for the petitioner, assisted by Ms. M. Kechi. Also heard Mr. D. Gogoi, learned counsel for the Excise Department, and Ms. Shivadas appearing for this point number 3. The petitioner, the petitioner's case is that, no, petitioner's grievance is that his technical bid has been disqualified. On the ground that the affidavit submitted by him regarding the petitioner not having any not having any excise shop / license. No, on the which had been submitted in pursuant to a earlier tender notice could not have been submitted again in pursuant to the present tender notice. The second ground of rejection of the petitioner's application, petitioner's technical bid, was that the signature of the petitioner was not found in some of the uploaded documents, which was mandatory as per guidelines. Next para. The petitioner's case is that he had participated in a notice inviting EBIT, bracket, in short NIB, dated 6/1/2024, for grant of IMFL retail off license for shop number LKP2, Harmuti Center, Harmuti, Lakhimpur district. However, the petitioner's technical bid was disqualified for the reasons stated above, and which are reflected in the comparative statement of bidders compiled by the state respondents, which is as follows. Which is as follows. Which states as follows. Page 76, okay. In red, okay. In red, huh? Next para. The petitioner's counsel submits that the petitioner had initially participated in an NIB dated, what was the earlier one? In an earlier NIB dated 6/1/2024 for grant of IMFL retail off license for the same shop. However, the said NIB was cancelled and the present NIB dated 6/1/2024 was issued. Who's that? In the NIB dated, no,
23.
in the NIB dated, no, the earlier NIB was 6/1.
6/1.
The subsequent NIB is actually 23/2.
23.
The subsequent NIB dated 23/24 stated that the terms and conditions of the previous NIB would have to be followed. Correct? Would have to be followed. The earlier NIB terms and conditions would have to be followed. No, what's up? Yes. He submits that the petitioner had submitted the affidavit stating that he had no excise shop or license in the earlier NIB dated 6/1/2024. And the same affidavit was again used in the subsequent NIB dated 23/2/2024. He submits that there being no bar for using the same affidavit in two NIBs, the rejection of, no, the rejection of the petition, the disqualification of the petition's technical bid on that ground was not justified. Full stop. He also submits that the petitioner was to submit his tender documents by uploading the same and also by submitting hard copy. He submits that the hard copy of the tender documents, which was the original tender documents, required to be signed. The uploaded copy was not required to be signed in terms of the terms and conditions of the NIB. Mr. D. Gogoi, the learned counsel for the respondent, for the excise department. What do you have to say regarding affidavit? I think he has got a point. Admit or not admit? No, okay, does not admit, just say.
The same has been submitted by him also. That is, I have annexed the private respondent number 5.
Oh, yes. Oh, yes.
That I have submitted.
Yes, yes.
So it has been relaxed in his case.
Submits that, he submits, submits that, the petitioner did not sign all the pages of his uploaded tender document. And as the same was a mandatory requirement, there was no infirmity with the disqualification of the petitioner's technical bit. Acha, one more thing, the petitions council, the petitions council. The petitions council further submits that the respondent number 5 had submitted affidavit stating that he had no excise shop / license in the earlier NIB dated 6/1/2024. And the same affidavit had also been uploaded in the NIB dated 23/2/2024. So, sir, he thus submits that the same yardstick would have to be followed for all the tenderers and as such, the respondent number 4 could not have been granted the IMFL, cannot be granted the IMFL, or and as such, the technical bit of the respondent number 5 should also have been cancelled. Anyway, if the petitioner's technical bit had been disqualified on that ground. Next para. No, continue. He also submits that there are many other grounds.
Even all the documents are not signed by the respondent number 5 also.
He also submits that the respondent number 5 did not sign all the tender documents
Which we have raised before the authority. Technical.
which had been uploaded. And as such, the technical bit of the respondent number 5 should also have been rejected. Any other ground?
Apart from that, this income tax return not duly certified by the CA.
First off, he further submits that. And the
return and
income
balance
tax return of the
And balance.
income tax return and the balance sheet of the respondent number 5 had not been certified by a chartered accountant
As required by clause.
as required by clause
6.
6 of the NIB. Pusta. Next para. Then I've said, no, Mr. Dil Gogoi have said, no? What have I said? Pusta. He however submits that there is no bar. He however fairly submits that there is no bar on the petitioner to submit the affidavit in the present NIB dated
23/2/2024.
23/2/2024. In as much as this, though he had submitted the same in response to the earlier NIB dated 6/1/2024. Correct?
Yeah.
Any further? Full stop. Next para. He submits that the petitioner would have to first cross the hurdle of overcoming the disqualification of the petitioner's technical bit prior to making a challenge to the responsiveness of the technical bids of other tenderers. Pusta. In this regard, he has relied upon the judgment of the Supreme Court in the case of Tata Motors versus this is the Tata Motors. Oh, you have not mentioned Tata Motors there.
That is Ronak International.
Ronak has been used there also.
This is Tata Motors. Paragraph 40 to 49.
Tata Motors Limited versus the Brihan Mumbai Electric Supply and Transport Undertaking bracket BESS and others. 2023 Live Law SC 467. And in the case of Ronak International Limited versus IVR Construction Limited, reported in 1999, 1 SCR 492, What's up? I've heard the learned counsel for the parties. What's up? With regard to the contention of the petitioner's counsel that the respondents could not have, with regard to the fact that there was no bar on the tenderers to submit an earlier affidavit submitted in another NIB. And in the present NIB, this court is also in agreement with the counsel for the petitioner that there being no bar for the petitioner to submit his affidavit stating that he had no excise shop / license in this NIB dated, in the present NIB dated so and so, 23 to 2024, which had been submitted earlier in connection with NIB dated 6/1/2024, comma. The disqualification of the petitioner's technical bid on that ground is not sustainable in law. The same is accordingly set aside. Full stop. However, with regard to the other ground for disqualification of the petitioner's technical bid at the technical bid evaluation stage is to the effect that the petitioner had not signed all the pages of his tender documents which had been uploaded. Full stop. In this regard, clause 7.6 of the procedure to apply, which is
Which, my lords,
which is a part of the terms and conditions of the NIB dated 23 to 2024 states as follows. Inverted commas, all pages of the documents submitted by the bidder shall be signed by the author, no, not sorry, 7.7, not 7.6, 7.7. The registered bidder shall also be required to sign, comma, scan and upload all pages of this bid document acknowledging the following. So. You think 7.6 and 7.7, you think that, huh? All pages of the 7.6 states that all pages of the document submitted by the bidder shall be signed by the authorized signatory and shall also be affixed with the bidder's entity's stamp, bidder entity stamp. Full stop, huh? Where is that other clause also?
10.4.3. Page number, you want to tell? Page 40, my lords.
Clause 10.4.3 states that the e-bid document shall be digitally signed, comma, at the time of uploading, comma, by the authorized signatory of the bidder. Then the other one.
Also, 10.4.4, the below one.
Acha.
Hard copy shall be
No,
signed.
no. Then and 10.4. You can keep that also. And 10.4.4 states that the hard copy shall be signed by the bidder or his authorized signatory with entity seal, comma, if any. Full stop. Clause 10.4 pertains to formats and signing of e-bid. So I think that clinches the issue. Gustav. In view of the petitioner not having followed the clauses as enumerated above, that is, he didn't, as the petitioner did not submit, put his signature in all the documents of his tender, in all the tender documents, comma. No infirmity,
Sir,
there
my
is no
question is
infirmity,
that same has been relaxed in his case.
there is no infirmity with the decision of the respondents in disqualifying the petitioner's technical bit. Next paragraph. The above being said, the question that is to be that is to be further looked into is as to whether the documents submitted by the tender documents submitted by the respondent number 5 had been signed by the respondent number 5 in all the pages.
These are the documents, madam. Flag mark, I have flag mark. These are downloaded from the website. So it's not annexed.
He should produce his own, my lord. Not my
These
documents.
are available in the
Not my
website.
documents, my lord. He should produce
These are
his own.
documents, madam,
He'll
anyone
produce
can
his
upload.
own. He won't produce my documents. These are my
contention
documents.
is that
I am going to look at only the official documents, Mr. Council.
So these are all official documents.
He'll produce his own documents.
We
He
can
has signed on.
download from the website.
Huh?
We can download all these documents from the
You go to
website.
civil court then. I'm not going to go into evidence. This is the official document. Why should I believe
No, madam, these
your
documents-
document was
that official document is without these particular pages.
Acha.
That's what I'm saying.
Okay. Show me those pages.
So this is what I am saying that
Okay,
tenancy
if
agreement,
those pages are missing, then we'll see. Those pages are missing.
tenancy agreement and the affidavit signed by the landlord.
But I can just. Then my lord will see his documents also.
No.
Then if my lord sees his documents, then my lord.
No, I've already said, I've already agreed. He's agreed. So why should I see that?
Yes.
This e-stamp,
Tenancy, my lords, it's on the vertical side, my lord, see the.
his signature is here.
No, that
This
is,
bottom is the signature.
that is the execution of the agreement, not in the token of verification of the document.
No,
What
no,
is to be done, my lord? It is agreement which need to be signed both the parties, but not the signature in uploading the document. Similar is the case in the next flag also, my lord. That is only signed by the that was sworn by the landlord, my lord.
That is signed, Mr. Council.
No, not by the respondent number 5.
But what about this e-stamp, this one? Where is the signature?
Second document is also not signed.
Well, still then, my lord, does he qualify, my lord, challenge this one?
No. You see, suppose it's like this.
Yes, my lord.
If he has been given 0 mark for answering A as B, why should another person who has given the same answer as him should be
Yes,
given
my lord.
1
My
mark?
lord, that I need to.
That
look
is the
into.
thing.
I have to look into that. It takes some years.
Then the interim model, all the records produced before your lordship, that is.
Let me see it.
Lordship. The first one is the agreement execution by both the parties. But while uploading, as per the terms, it has to be, another signature has to be there of the tender.
Promotion value. Promotion. I will make promotion.
So I think if that is there, then.
No, my lord, my lord, this is a document which is provided by the landowner. This is a document and these
Whatever it is a
tenancy
part of,
is not there, my lord.
Mr. Council,
My
it
lord.
is a part of the tender document or not? If it is a part of the tender document, then it goes. End of the matter.
In that case, my lord, we will produce these original documents on 4th.
Okay, but it'll be it'll be downloaded. Then he, then
We can
they'll
bring
make
the original- no,
photocopies.
my lord, we can bring the original files.
Okay, but
Should desires.
and we stay this then.
No, my lord, in that case, no stay. my lord,
No,
because
we
he
are
has
giving,
not-
I'm giving a say whether you want it or not. That is not your prerogative, Mr. Council.
No, I'm not saying that. But the first initial question has to be answered, my lord. Does he also qualify?
Mr. Council, it's like this.
My lord, I got the.
If it
process
was,
point.
if it was on a different point, okay, I would have agreed with you.
My lord.
But on the same point, how can you do it? He's wearing yellow shirt. Because he's wearing yellow shirt, he gets 10 marks. Because you're wearing a yellow shirt,
My lord,
you get 0 marks. How
in
can
that
it be?
case, my lord may make it subject to outcome if possible, because my lord, third party right has been created, my lord. No stay, my lord, no interim, my lord, because 15th
Okay, anyway, let me write this right. Mr. D. Gogoi, Learned Counsel for the petitioner. Excise Department submits that letter of acceptance dated 15/3/2024 has been issued to the respondent number 5, though the license has not been granted to the respondent number 5 till date. Next paragraph. Then we come to me, na? Is it- okay. On considering, no, Mr.
My
D.
lord,
Gogoi,
I'll pause for a moment. My lord, page 34 for the read petition, my lord. Once again, my lord. The bids, the documents comprising the bid, my lord.
page 34.
Documents comprising the bid. These are the documents which comprise the bid. And this has to be uploaded. And nowhere it says there has to be document by the landowner.
Mr. Counsel, I'm not on that. You have brought the
My
document.
lord,
When you're so fast, he's saying that he has admitted
my lord,
to certain things. Now, you had brought this, you had submitted this to the court
my lord,
for perusal. Now you cannot say that this is not part of the tender document, right?
my lord.
Right. On considering the fact that, on considering the documents submitted by the respondent number, on considering the documents submitted by the Mr. D. Gogoi in relation to the bid documents of the respondent number 5, this court also finds that this court does not find the signature of the respondent number 5 in with regard to, which is that document, just show me once more. I have to. Yeah, unfortunately, you should not have put that.
No, my lord, we should be fair. It's not that getting a stay with this kind of blur going on for. We are not like that, my lord.
No, if you were fair, you should have said yes. You do
No,
not
my
have
lord,
to
now
show
I
me.
have got point out.
You
I'm
should,
not sure point.
if you why didn't you
No,
put
no,
this?
that's now pointed out. That's why
Yeah.
he's woman.
Huh?
Otherwise, I could have.
The signature in the huh? Respondent number 5
Tenancy agreement.
Tenancy agreement is there.
in the, just a minute, please do not disturb. In the certificate number IN-AS 730-29593 78751W. Huh? You take a photocopy of this. The same is made up, the same is also kept as a part of the record in the case record. and marked as an exchange. As Mr. D. Gogoi submits that he will produce the documents, original documents of the respondent number 5
5.
on,
4, 2, 3, any date, my lords.
I leave it up to you.
Take it with you.
4, we've got, I think, we've got the full bench.
Oh.
Full,
Second, my lord.
again. Okay, 4.
Second, my lords, it's a hearing.
We've got a full bench.
Oh,
With two,
fourth, my lords. Fourth.
4. So stop. Till then. Status quo. Till then, no license should be granted to the respondent number 5 by the respondent authority.
Till next statement.
Obliged.
All right. All right.
Got no instructions.
No, your lordship, and there is no admission also.
There's no admission.
There is admission, doctor.
Where?
At the last page. They've admitted the balance.
That is by the executive engineer.
Whatever it is there, he's from the department. It's the executive.
How
engineer.
much? How much is the amount?
Not much, lordship.
52 lakhs.
52 lakhs.
52 lakhs is quite a bit. What do you mean not much? When you add up all these amounts, comes to quite a bit.
To say there's no admission, that's ridiculous, please.
Correct.
Lordship, admission has to be done by the chief engineer.
Oh, really?
As per Tamsher Ali, he's right. As per Tamsher Ali.
Yes, sir, Tamshir, yes, but anyone from the department who the order was given by the executive engineer, that also had to be taken into account. The person who gives the order
No,
confirms.
that is correct. But then as per Tamsher Ali, the full,
That was a different matter altogether. The facts are different.
but that is what we are following.
The facts are different.
Because
get the
usually money suit should go to civil court, but then
They-
we are entertaining. But then to ensure that at least, you know.
No,
there is
let
a
him cover the
admission.
response, Lordship.
Let them come.
I'll just get the instructions whether the amount is admissible.
Yes. Miss M. Kalita, Learned Counsel appearing for the
PHE department,
PhD department is granted a further
2 weeks time.
2 weeks time to obtain instruction and file affidavit if necessary. With regard to the contractual dues payable to the petition. This is the matter after 2.
13 and 14 are also same. Same order.
I think,
Amount is different.
Huh?
Or same order.
is this the Jal Shakti thing? No.
No. Jal Jeevan?
Jal Shakti, Ministry of Jal Shakti, no.
No.
NRDWP. National, this is a rural water supply scheme. Same order.
You see, one thing is that there is already that E has given a note.
Lordship.
Now the problem is that will you really be able to get instructions within these 2 weeks? Or is it,
Like this.
So because these are all central funds, Doctor.
We have written to the chief engineer as well as the executive engineer. We have written to both of them.
and no instruction? Okay, just write one thing. She submits that, before this the matter after, she submits that letters have been written to the chief engineer and executive engineer for instruction for stuff. However, the same is not forthcoming till date. This is the matter after 2 weeks. You see, because we can't wait forever also.
No, Lordship, I don't, it's not nothing to do with the councils, but the persons executing these are all central schemes for rural water supply. So what money comes, it just they're not prompt in paying, and we also have no other option but. to
No,
come.
but then you see, the problem is like in one case, they've been taking the plea that the central funds have not been coming. So that is another thing. The thing is that supposing we pass an order, you verify and pay. Okay, they verify, yes, admitted amount. But if they take the plea, then the central funds are not coming.
But there are lots
That
of documents which show the central funds in most of the schemes have come. In fact,
No,
they
so
are-
that would have to be here. That's not in your writ
that is,
petition.
that what has happened, Lordship. No, they have never said central fund is not coming. Funds have come. All the central funds come. It is, in some cases, Lordship, what happens if you're MSME, in addition to the principal, you have to give them a huge lot, pay a lot of interest. That is what center will not pay for the interest, okay, because it's your delay. But there's a list, if on the website, we find how the scheme fund comes from the center. And they have been clearing central funds. Of course, the interest,
If you can show that in the addition,
I'll-
you make a additional affidavit.
I'll show that, the central
So
fund.
you show that the central funds have come and they've been received by them.
It's not, I mean, the councils can't do anything, Lordship, because direct instructions never come.
That's what-
That's not right. Even if the funds.
No, but.
No, I'm
but-
not talking about the council.
No,
I'm talking
but-
about the instructions.
No,
are
but
there.
one thing is that in some cases, the instructions do come. In some of them, they have come.
It does come.
I also have my own experience of over so many years.
Okay, we'll wait for.
Lots, 12, 13 and 14. is the
Yes, same order, huh?
Highly obliged, Your Lordship.
Item? He was here all along, whole day. Just waiting, we'll wait. And this is a case, I mean, this has to be allowed.
Already ordered in.
In her favor, he's already got.
It's already there.
Heard Miss R. Chowdhury, learned counsel for the petition. She'll be appearing, I think, in the meantime. Also heard Miss Udas, learned counsel for the respondent number 1 and 2. 1 and 2,
Or two also.
1 and 2. No one appears for the Tezpur Municipal Board. The case of the petitioner is that the petitioner is a tenant. Acha, you're for the Tezpur Municipal Board.
No. I was just checking.
The petitioner is a tenant under the Tezpur Municipal Board, having a shop, having a room, having a shop or room,
One shop, my lord, that was.
having a shop bearing number 154A at Chowk Bazaar, Tezpur. The shop is in one room, which has been divided into two shops. Room bearing number 154 has been allotted to one Mr.
Yeah, Ali, Lordship.
A.R. Ali,
Yeah,
while
at present he is dead.
shop number 154A has been allotted to the petitioner.
Lordship, I have taken 154A from ER Ali.
Acha,
Subsequently, I became tenant under Lordship Municipal Report.
that's what I'm saying. So why should we go into that?
Lordship,
You're now, so 154 is with whom? Your
150,
154A is with you.
yes,
You
Lordship.
see, 154 was one room.
Lordship.
There were two persons. It was divided into two because, so who is looking after the other one? You don't know.
154.
154,
ER Ali, legal heirs, Lordship.
legal age of,
Lordship.
acha. 154A is what have I said? Is in the name of the legal heirs of A.R. Ali.
154.
Huh?
154, Lordship.
154, that's what.
Yes.
Due to a fire that occurred on 8/5/2021, all the shops of the market, including the petitioner's shop, was burned down. The Tezpur Municipal Board thereafter provided financial assistance to all the affected shopkeepers and allowed them to reconstruct their shops. However, the petitioners and Mr. A.R. Ali, Year Ali or Year?
YEAR, yeah.
That's what I was thinking. Why, and Mr. Yar Ali were not provided the financial assistance and neither were they allowed to reconstruct their respective shops. On the pretext of pendency of the property dispute between Yar Ali and the petitioner in RSA /105/2013
19.
19 pending before this court. Next para. Ms. R. Chowdhury, learned counsel for the petitioner, submits that RSA 105 of 2019 has been disposed of by this court by judgment dated 21/7/2023. Wherein
Page 69, 80.
huh?
Page 69 to 18.
Wherein this court has upheld the judgment dated 20/07/2018 and decree dated 21/07/18 passed by the learned civil judge Tezpur in title suit number 12 of 2016 and the judgment and decree dated 30/09/2015 passed by the learned Munsif number 1 Tezpur in and wherein no has upheld the imputed assessor and partly reversed the judgment and decree dated 30/09/2015 passed by the learned Munsif number 1 Tezpur in title suit number 96/2006. Further, the subsequent further appeal
Title appeal findings, lordship, page 62.
62
62.
Okay.
In respect to issue number 6 and 7, there was a finding, lordship.
Don't say further. Next paragraph. In the I said title suit, no, it is title appeal actually.
Lordship, title.
Title appeal 12 of the title appeal 12 of 2016. Huh?
Title
Next.
suit, lordship, suit was dismissed.
Ah.
Then first appellate court partly reversed the judgment. Suit was decreeing the 156 in favor of the plaintiff and 156A in favor of the defendant.
154.
154, lordship. 154 given to the plaintiff and 154
So who filed the suit?
plaintiff, lordship.
Who is the plaintiff?
E.R. Ali, lordship.
Yeah. Okay, what have I said? No, you have to change the thing, entire thing, I think. What have I said in the beginning? No, upheld the judgment dated 20/07/2018
Lordship.
and decree dated 21,
No, Lordship.
no,
Upheld only this judgment.
upheld the 27/0/18, huh?
Yes.
27/18. Passed by the learned civil judge Tezpur, Sonitpur, in title appeal number 12 of 2000. Full
Yes.
stop. Okay, that's
Whereby Lordship, this decree was given, page
Ah,
60, whereby
ah.
the present page
Yeah.
62 was given.
next para. In para 62, para 32 of the judgment dated 20/07/2018, passed in the in title appeal number 12 of 2016, comma. The it was held that who- I think there's something wrong. Look at page 62.
Lordship.
Hence, in view of the above discussion, it is held that the plaintiff has right title.
Yes, Lordship. Plaintiff has right title over 154 only.
That's
There-
what, but then it says here, in room number 154B only, that's what it has said.
Lordship, it was for the room number for plaintiff and.
No,
in my-
come to page 62.
Lordship.
I think it's made a mistake.
Whole room was 154.
I
That
know.
was parted.
Correct.
So plaintiff was claiming the right.
Whole
title-
room, whole room.
Whole room.
But then the court has said,
Sir,
it is held that the plaintiff has in view of the above, it is held that the plaintiff has right title and interest as tenant in room number 154B only.
Lordship, B 154B and 154 same room, Lordship.
I know.
And we have 154A.
Acha. Okay, 154A, 154.
Yeah.
Yes, I got mistake.
Or your Lordship can
Because I
simply say that, but the first appellate court held.
No,
that-
it's okay. So what have I said? That the plaintiff, here Ali, had right title and interest as tenant in respect of room number 154B only, and not the whole room number 154, comma, which also comprises of room number 154A. Full stop. Next. In view of the affirmation of the judgment passed by the first appellate court entitled appeal number 12 of 2016 by this court in RSA 105 by the High Court in 105/2019, comma, room number 154A. No, the present petitioner has right title and interest as a tenant in respect of room number 154A. Accordingly,
We have filed representation on 1st August 2023, annexure 3, page 81, before the municipal board, Lordship.
accordingly, there is no reason to deny the petitioner the benefits that were given to the other shop owners, shopkeepers whose shops had been burned down. Full stop. As the petitioner has submitted a representation dated 1/8/2023 before the Tezpur Municipal Board to reconstruct his shop and for renewal of his trade license, comma. So we direct him to do it.
Lordship.
The respondent number, the Tezpur Municipal Board.
Respondent number 3.
No, don't say Tezpur Municipal Board, just say the Tezpur Municipal Board Chairman is directed to take a decision on the petitioner's representation dated 1/8/2023.
Lordship, I have a judgment which says within 15 days, Lordship, trade license has to be issued, Lordship. as
Anyway.
the-
The decision within a period of 1 week from the date of receipt of a certified copy of the file.
And to consider the case of the petitioner.
And consider the case, the first step, as keeping in view the fact that this court has affirmed the fact that the petitioner was a tenant of room number 154A.
Apply.
That petition is accordingly disposed of.
I mean, item 6.
Surety department has got some. Yes.
So who is for the, so,
Maple Lordship.
okay, so your case is that you are the highest bidder,
Yes, my lord.
but the fishery has been settled with the respondent number 7,
Yes,
whose bid is lower than yours.
yes,
That's the only case.
yes, my lord. And that, my lord, the single man set aside the settlement of the private respondent, my lord. And directed to the department to face settlement. So accordingly, settlement in favor of me, my lord.
Then
My lord, the private respondent approached the honorable division. man.
division bid.
And division man's demand the matter, the single man on the conclusion part, my lord, where the technical be so defective, that conclusion, man.
Let us see the division bench order.
My lord, division man's order, my lord, additional affidavit filed by the respondent number 2, my lord,
Page.
page, my lord, 169. And single man's order, my lord. Actually, man, kindly see single man's order, man. One by one, you will come, my lord.
Yes, sir.
169.
Where is that where is the division bench order?
169, my lord. 169 round base, my lord. This additional affidavit filed by the, my lord, AF, my lord. My lord.
Okay. So the AFDC had said that your bid was defective.
No, my lord.
Huh?
May I say, if we
No,
can,
no.
the same.
Who was the writ petitioner? You're the
I'm
writ
the
petitioner.
My lord, kindly see the manner, they have received a earlier settlement order in favor of this. There, my tender was not defective. That was excellent, my lord.
Huh?
My tender was not defective, my lord.
No, no, I know, but they have said that it was defective. No,
No, my lord. May I say,
just a minute.
it's a very typical.
Huh?
Yeah, it's something critical, lordship. So, initially, lordship, what had happened? Initially, the petitioner came before your lordship challenging that his bid was rejected only on the ground that it was he gave exorbitant rate, and we have initially AFDC has settled to Pawan Hazarika, lordship. There is respondent
That's
number
point number.
7, respondent number 7, lordship, initially, and thereafter what had happened? The case was during adjudication, lordship, one writ appeal number 8 of 2021. Another matter, lordship, has came up before the division bench, lordship, where the decision,
Regarding the same fishery.
not fishery, regarding the same issue on the ground that where this petition was rejected, the similar ground, lordship. Here, lordship, in the writ appeal number 8. 8 of 2021, the Honorable Division Bench has adjudicated one point that AFDC cannot, here is a tender clause number, lordship. Can you go to the tender clause number, page number?
Just a minute. Let me read.
No, it's
Let me read. Wait.
not yet. 36 number page, lordship, on the petition, lordship. It's very clear, lordship. One second. Okay, everything will be clear, lordship, if lordship goes to page
Just
number
a minute.
45, lordship.
Yes, page.
Page 45, lordship. How we petition, lordship.
Page 45.
How we read petition. Is the translated copy of a Brahminic law, lordship. Here, clause number 4.7, lordship.
Page 45 is the vernacular copy.
No, lordship.
There are two. Wait, there's another 45. Let me see.
That is the FPT in opposition. Oh, FPT in opposition, sorry.
This is the 4.7.
Yes, 4.7.
Okay.
This is the.
The problem is there are two paginations out here. Okay. Yes.
Lordship, the crux of the case starts from here, lordship.
Okay.
4.7, lordship. Here, lordship, if the tenderer offers excessive value revenue compared to the one specified by the corporation, it will have the power to take final decision after considering all aspects with regard to acceptance, non-acceptance of the settlement by the tenderer. It has been found in earlier occasion that some lessees become unable to manage the fishery for having quoted excessive value revenue. Eventually, loss incurs in revenue and lessee also suffers financially. Furthermore, the rate of production of fees and scientific basis for financial gains should be proportionate. The corporation may not accept excessive and unreasonable rate. On that clause, the AFDC prior to 2021 was rejecting the bid of highest bidder on this ground, 4.7 lordship. This ground has been struck down by the division bench. Lordship, I've given just a copy lordship, appeal number 8 lordship. That I have marked this lordship, para number 7 lordship. 7 lordship. I've,
Yes.
this 4.7 has been struck down lordship. In this repetition. So here lordship, here, Lord, applicant has attention to that.
Wait, now what do you want to read? You have given me this.
Here, this part is being struck down by the division bench lordship. That by this clause lordship, by considering this clause, his bid was rejected. Pawan Hazarika bid was given lordship, earlier rounds. After passing of this order, here this order was passed lordship. This after division bench order lordship, the single bench, considering the order of the division bench lordship, has passed this order. This
That since he is the highest bidder, he should be given.
also that the corporation does not have the power to consider that excessive rate should be considered, lordship. Here, lordship, excessive.
Where does it say excessive rate? Where are you reading? You just showing me one paragraph, that's all. Where's the finding?
Finding, yes, lordship. Finding is in.
You're jumping from one place to the other.
Finding is from the settlement order can be. Findings is from settlement order.
No, in this division bench order, what is the finding as to why the highest bid should be taken?
Lordship, that is. My lord, there are 6, my lord. There are 6. These orders, my lord, division bench order, my lord. This case, my lord, the
Mr. Counsel, one at a time.
sorry. This is this part 8, para number 8. It was been explained, lordship. This 7 is being explained. In para number 8, the petitioner delivered before the court that in the resolution pattern 1, only corporation which is NIT dated minimum value which is the present has been given. About the case before the court has when the highest tender value was not then how the corporation may say that it has been exorbitant.
Which one are you reading? Which judgment? This one that you gave me?
Yes, lord.
Para?
Para 7 and 8.
Why are you reading para 7? Para 7 is just the court
Court
of the law of the
Yes, but
of the law.
that was being struck down, lordship. Here the similar.
That's what I know. It's been struck down. Now I want to know the reason why it was struck down. Where is it? The reason.
Single pension order accepted.
What are you reading? No connection. Para 10, I think, is got something to do with it.
Yes, my lord. There are 10 and 16, my lord. The 6 is in here, 6 is. There are 6. That part.
Just a minute.
Single bench order to 9. Okay, I'm sorry, Lordship, without going to that single bench order, actually, in that case, Lordship, we were supporting Pawan Agarwal, AFDC got the appeal. We filed the appeal, Lordship. Without the single bench order, the court cannot adjudicate that. That's the matter. It will,
I do not know where you're jumping from one end of the spectrum to the other.
yes, Lordship, that
Yeah,
one,
yeah, yeah. You please decide where you're going to stand. In the middle, on the top of the fence, where? Or on the side, right side, left side, where? You're everywhere right now. That's the problem.
single bench order. Man, take it out, Lordship. Thank you.
So outright was taken from the highest bidder.
May I just assist you?
Huh?
May I just assist?
Yes, yes, please do. I've been taken from this end of the
Page
field.
21
Page 21 of the.
of this.
No, let me get it straight. One thing is that he is the highest bidder.
Invalid has been, invalid.
Invalid, okay. It's a technical bid he failed.
Yes,
Oh,
that is the reason.
No, no, Lordship, that I'm asking,
their paragraph,
that is not our stand, Lordship. There is a single bid system.
Affidavit is there. my
No,
lord.
no, affidavit is, that part is not there, Lordship.
okay,
That- No, Lordship, that is the,
no, no,
Para 6 of.
just let me try to understand your case.
Lordship, yes.
Para 6.
We are supporting him, Lordship.
let-
So we have
let-
even after.
Let me try to understand your case.
No, Lord, yes, kindly, my
Ju-
Lord.
Just a minute. Either you listen to me or you will have a hearing on another date. Now, the thing is that in the tender, you submitted the highest bid.
Yes, Lordship.
Tender was settled with point number 7.
Seven, Lordship.
So that means that you supported him?
Yes, till 2021.
Okay, then he filed a case.
Before, prior to 2021, this,
Mr. Counsel, whether before or after, how
yes.
does it matter?
Lordship, yes,
So he filed the case,
Lordship,
one writ petition,
Lordship,
writ petition went in his favor.
yes,
Single judge said give it to the highest bidder,
Lordship.
correct?
Correct.
So that means it implied that the technical, he was qualified, technical bid qualified.
Yes.
Who went in appeal? You went in appeal.
Appeal,
Now the appellate court said, the reasoning given by the single bench for stating that he should be given the bid because he's the highest. By referring to the other judgments
Lordship.
has not been clarified.
Yes,
No.
yes, Lord.
That division bench has said that your lordship will tell me division bench judgment. It will take 2 minutes. Your
Yes.
lordship will tell you. Division bench judgment, your lordship will say page 169.
169.
Yes. Starts at page 170. I'll read from the middle portion. Having heard and considered the submissions advanced by the learned.
Just a minute, let me turn to the page.
170.
170, yes.
Having heard and considered the submissions advanced by the learned counsel for the parties, and after going through the impugn order and other materials of record, and what is the material, I'll show one paragraph. We find that the bid of the appellant was accepted, and the bid of the three other contenders, including that of the respondent number 1, the petitions were rejected by the managing director on the ground that their bids were technically defective.
Okay, they were
So now,
technically disqualified.
Paragraph 6, your lordship will kindly see their affidavit, page 21.
Page 21.
One.
170, then page,
It is
paragraph 6.
6. This is the affidavit filed by the AFDC. So this was not considered by the learned single judge. So therefore it was interfered with.
Para 6.
6.
Yes.
That the statements made in paragraph 6 of the repetitions are not correct, and as such the same are denied. It is denied that the petitioner's bid was declared to be valid. Instead, his bid was found to be technically defective due to defaulted DPR of bill, development and
No,
excess.
no, where are you reading? Page, para 6, page 6.
Page 21.
You wait for me to turn to the page also. Yes. Where? Para?
Para 6.
Para 6, page 21.
Yes. The statement made in paragraph 6 of the writ petitions are not correct and such the same are denied. It is denied that the petitioner's bid was declared to be valid. Instead, his bid was found to be technically defective due to defaulted DPR of bill, development and excessive exaggerated rate of fish production. In this regard, the deponent begs to state that in pursuant to the tender or for bill under Nagaur district, 5 contenders submitted their bill tender. Out of the 5 contenders, tenders of 3 numbers of contenders were found to be technically defective, including the tender of the petitioner for the above stated reasons, and the same is reflected in the order dated so and so, issued by the managing director.
Correct. So his tender
Yes.
was found to be defective.
Defective. This was not.
No. Just a minute. Only on the ground that he had submitted an exorbitant rate. No
No,
other
no,
reason.
No.
Excessive.
Excessive rate,
Excessive.
exaggerated rate.
Rate of fish production.
Yeah.
Because this is on the basis of DPR.
Lordship may go through the
In the DPR, my lord,
173 settlement order.
Page
173 settlement order.
173.
Yes, my lord. Settlement order in favor of private respondent.
Yes,
Lordship, may I read, Lordship?
yes.
I read from the living portion I am reading. The minimum.
Where, which line?
The third paragraph. From third paragraph.
Okay.
The minimum targeted.
Where is it? In the middle of the page, top of the page?
In the just 2 lines before.
Okay.
So before tender, the
Just
corporate.
a minute. Just start from the minimum targeted lease value.
Yes, okay. Minimum targeted lease value of Laupani bill is 4,64,500. After opening the tender documents, it is seen that Sri Basudev Biswas has quoted, so 11 lakhs rupees.
Who is he?
This writ petitioner, madam.
Okay.
Writ petitioner for the first year and rupees 11,50,000 each for the rest 6 years. Sri Pawan Hazarika has quoted rupees 7,50,000. This respondent number 7 for the first year and 7,50,000 each for the rest 6 years. And Sri Manoranjan Biswas has quoted rupees 5 lakhs for the first year and 5 lakhs 10 years each for the 6 years. Before tendering, the corporation fixed the minimum revenue considering the fish production on the bill concerned as to smooth running of the bill so that the selected lessee could not suffer to deposit government revenue. In the event of accepting the bid amount submitted by Biswas, he may suffer loss considering the previous record of the bill. Further, in view of the ecological aspect of the bill in concern, result of this fiscal production is not good position as there is other problems on the bill. Keeping in view of the above noted bid amount of all the 3 bidders, it is found that the bid amount quoted by Sri Basudev Biswas is abnormally high, which may cause lapse or default at the time of payment of revenue, and it would result to face loss to the fishermen engaged by Sri Biswas is unreasonably and cannot be fulfilled in view of the ecological aspect of the bill. The bid amount submitted by Sri Pawan Hazarika accepted in view of the minimum revenue fixed by the corporation. The said bid amount reasonable and affordable by him, and it may not cause any difficulty in payment of revenue and get the ecological surrounding, including the water level of the bill. Lordship, this actually this order was passed by AS12 managing director. We have already suspended him. Criminal case is also going on against this managing director. Lordship.
So lots of scams were also there also in this case, Lordship. Even for loss of revenue, in the Director of Vigilance, we have filed cases also. Due to around 100, several crores of rupees lost by giving direct settlement this way. We have given cases also. The case is being registered also. Investigation is going on.
This is what date?
20
22, 5,
2020, 22/5/2020, Lordship. So Lordship, here the similarity is that exactly similar to Interpol. Actually, for clarification of this case, Lordship, actually we went to
No,
the
this is what, with regard to what? With regard to this case?
yes, Lordship.
Yes, yes, but it
This
was
case.
initially settled by the private respondent. That was settled.
So NIT was issued when?
My lord, NIT was issued, my lord, 18/2/2020.
18 to 20.
Yes, my lord.
Settlement made
Settlement made, my lord, initial settlement was in favor of the private respondent 22/5/2020.
22,
5/2020. 2020.
20. Then WPC number?
WBC number 3454, my lord. 2020.
3454 of 2020.
Yes, my lord.
Decided on
Decided on, my lord, 9/4/2022.
9/4/22.
19.
19/4/22.
Yes, my lord.
Then what happened?
Then, my lord, settlement issued in favor of me, my lord.
Settlement dated
21/6/2022.
21/6/22. Then
Then again, we have taken, we have stayed his settlement, lordship, 15/6/2023.
you have stayed.
Yes, Lordship. In view of the prevalence of the
Sure,
cases,
sir.
Lordship.
Huh?
We have kept in abeyance, Lordship.
Acha, because of WA.
No,
Yes.
because of
Yes,
this,
sir, yes.
How can you say there's already a decision in his favor? Settlement has been made in his favor.
Lordship, because of the WA, Lordship.
WA, say, that's what I'm saying. WA number
248.
248 of
2022, my lord.
2022.
22. Decided on
1/6/2023.
1/6/23.
Lordship.
Then remanded back to the single judge.
Yes, sir.
Now we have to decide.
Yes,
Yes.
nobody is running. We are in position.
Nobody is running.
No daily basis.
And so his technical bid was disqualified because of excessive rate,
Yes, Lordship.
exaggerated rate. That's all.
Exactly. And from our view, Lordship, when we made the appeal in this WA 8/2008, this was the appeal and Lordship. So court has directed us, we cannot give this way. By giving excessive, by
So now you are supporting him.
now, yes. After this, I was the person who appeared before in WA 2021, Lordship.
Whether you appeared or someone else appeared, that doesn't matter.
So we cannot give this way.
Huh?
Lordship has to decide what in its own merit, Lordship, but we have to support him because of this other petition. WA 8/2021.
What is WA 8? What happened out there?
In their Lordship, court has said that we cannot put this exorbitant rate as a clause for rejecting the higher bidder. The reason for rejecting the higher bidder.
Is it correct? In WA
His
8,
case, it is not similar to that.
no. In WA 8, what was the decision of the division bench?
On the decision of the division bench, when I appeared there, paragraph 6 and 7, which I read, earlier one was a different case because probably they have taken into consideration the highest, that excessive rate.
Lordship,
Where is that? Show me, okay, Mr. Sharma, where is it? Tara? That it should be given to the highest.
That order was passed. Kindly go to page 45, that 4.7, considering 4.7, that settlement order was passed, Lordship.
4.7 of the Rule Act,
No, 4.7 is tender B,
page
45. So then, at that relevant period of time, the corporation considered 4.7. The appellate court said you cannot use this clause. Actually, I should have. Single mention.
Division bench also my lord, reflected para number 6 my lord.
So this 4.7 has been set aside.
Lordship. In the single bench, it has been set aside, Lordship. Actually, so I told that I initially submitted that I should have brought the single bench order also. Because single bench set aside this 4.7. We went to the appeal,
In this WA8.
WA. Court has said that single bench has rightly passed the order.
Okay, so this,
This,
uh,
so Lordship needs the single bench order also to, actually, I should have brought that order also. That maybe collected, Lordship.
no, why do you want me to see the single bench order?
Not necessary, Lordship, Lordship. If Lordship requires, Lordship.
I don't know, you're neither here nor there. It's like we are running the 1500 meter race. And after running 1000 meters, you tell me, we were running actually the 100-meter race. What am I doing now? Where are we now? Are we running 1500 or have I finished the race? What?
Finish the rest, Lordship.
Finish the race. So the single bench judgment nothing. So what remains now?
Nothing remains, Lordship, as per me. Lordship makes. Lordship, our stand, this stand is simply, this stand is simple, or 2 lines, 2 minutes I will take. This stand regarding briefly, Lordship. Initially, only 2 minutes, Lordship.
No, it's okay. You're confusing me more and more.
No, Lordship, I'm clearing it, Lordship. Initially, what happened, Lordship? Considering 4.7 of the tender clause, and that we have the power that we can.
Earlier, 4.7 of the tender clause was used by you to deny him the settlement.
Yes, Lordship.
Now, when you have settled the matter with him, the division bench in another case
Yes.
has set aside that 4.7.
Yes. You will take it. Yes, Lordship.
So how is it so? How have you cleared the cobwebs?
No, single bench firstly set aside, then division bench reaffirmed the single bench order.
That's what I'm saying. Now, how do you reconcile your earlier decision with the present decision you're taking
Yes,
now?
that I want to submit, Lordship. Here the repetition was pending since 2020, Lordship. So this matter is decided in 2021. So considering the fact that division bench has opined that this exorbitant rate cannot be be a reason for depriving the highest bidder. So we have decided to go for it, to consider that the division bench order. We placed it before the single bench. Single bench while passing the order, the division bench says it was not clearly stated what is the difference between, what is the similarity with the rate appeal number 8/2021. That's my understanding, that is the reason for remanding back the case to your Lordship.
So what am I supposed to decide now?
Lordship, my submission is that, Lordship, here the case is exactly similar with the 8/2021. So the settlement provided to them.
I think I have heard enough. I think you're creating more problems than solving them.
Lordship.
Yes, Mr. Das.
But your Lordship will kindly see, I'll just read paragraph 6 and 7 of page 21. Okay.
Page 21. Page 21. Page 20. I've got two pages. Which one? This is the tender notice.
This is the affidavit filed by the managing director of the AFDC.
Okay, page 21. Yes.
Paragraph 6 and 7.
Yes.
Yes. His bid was found to be technically defective due to defaulted DPR of bill development and excessive-
Yes, defaulted DPR. What is this?
I'll come, I'll just. Lordship will give me just.
Yes, yes.
An excessive exaggerated rate of fish production. In this regard, the deponent excessively in pursuant to the tender lawfully been under Nagaon district. 5 contenders out of these 3 were technically defective, 2 were technically all right. including the tender of the petitioner for the above reasons, and the same is reflected in the order of the issued by sir. Now, paragraph 7, your deponent vexes state that petitioner may have quoted the highest rate, however, his tender was found to be technically defective by the tender selection committee because of defaulted DPR of field development and excessive exaggerated rate of fish production, and as such, his tender was found to be invalid and accordingly his tender. So therefore.
So it is not with regard to his higher bid or
No,
anything, nothing,
so
that's not the issue.
Let them not mislead the court. My lord, when
Ah.
I came before the division bench, my lord, division bench, I have shown this paragraph. It is not because of those, if it would have been, my lord, because of the highest bid, then the things would have been different. I would have fallen under the same
Correct,
category.
correct,
Same category.
correct.
Here, this is their affidavit. Now your lordship will kindly see page 51.
Page 51.
Here, 10.4. This is their bid documents.
10.4.
The financial tender of only those tenderers whose technical tenders are found correct and acceptable in all respect will be open. Page 60, your lordship, can you see? Mandatory. Page 60, last one.
Yes,
The tenderer will have to submit detailed estimate for increasing production of fish and revenue for 7 years with the tender. The details of the proposed developmental works to be undertaken in the fishery, the tentative production of fish and profit and the revenues to the corporation in every year should be clearly reflected in the estimate. So this is the picture. This picture, they have given it a page. My lord, petitioner's picture is at page 79. That is the DPR they have given. Fish production and revenue payment of fishery. Page 79. So these are the technical aspect of the matter, my lord. And respondent number 7's my lord, DPR is at page 83. Detail.
okay, how does that help? So now the basic thing is,
It is not because of
so
the
his
price.
technical bid was cancelled.
Technical bid was cancelled.
But
because of the reason.
was it, the only problem is, yes, was-
Kindly say, Learned Council say my technical is defective. But their tender, my lord, settlement order, there is nothing, my lord. Kindly see my 173, my lord. Not defective, my lord. Kindly see my settlement order. This settlement order.
you see, the problem is, you see, was the disqualification of his technical bid, was any order issued?
Lordship, here.
No, I think a record is necessary.
Proper record is here, lord.
Give me the technical bid evaluation
Lordship.
done by the technical bid committee.
Yes, that is, I have the photocopy copy. Kindly, my original copy.
Yes, show me the original. Mr. Bidi Das, tell it to look, is there?
Settlement order.
Because it might be in vernacular, so.
No, in English.
Oh, you know.
Settlement order, my lord, nothing, my lord.
This is the order.
I want to say.
That is the order.
Order, lord.
No order.
No orders, no orders. No, don't show me anything. I just want to see the technical bid
Here,
evaluation.
Yes, sir.
That's all.
173, my lord, settlement order. Your settlement, my lord. There is nowhere mentioned that defective might be to the defective, my lord. Kindly see, my lord, that part only. Page 170. Lordship, here, one very important thing, lordship, that the
I don't know why you are going overboard in trying to help someone. You should help the court. It's their first duty.
my
You
lord,
see, you are speaking in a forked tongue. On the one hand, you did not help him. Now you want to help him.
here,
If we file a case against you, after that, now you want to say that, yes,
my
our
lordship,
earlier thing was wrong.
My
Anyway,
lord,
wait. No, let me see. Which bill is this? Lao Pani.
two settlement order here, my lord.
Unreadable.
I will place the record.
Oh, give me the records. Where is the record?
Lordship, this part is not there, Lordship. Original is on.
Eh, you bring the unreadable documents.
My lord, I want. Settlement, not that one, Lordship.
I want that particular page only, the bit.
No, not that particular, this is a settlement order, Lordship. My lord, technical order, the original one, I have to produce a record. My lord, original. Here, Lordship, one more thing, Lordship, one, just before contrary, I will place a record. My lord, here is two settlement order, kindly similar to one page 30.
No, no, I'm not looking at any settlement order. Both of you are confusing me.
No, no, my lord. At the same time, my lord, same date, one is annexed here in every. Here, another is right, lord. These
You all are both helping each other and speaking in crossroads to each other.
Lordship. No, Lordship. Here,
You all both want to help each other but speaking at crossroads with one another. Now, which path do I follow? This way or this way? Or this way? No problem.
okay, Lordship, this record I will place tomorrow on next day, Lordship. This or if Lordship needs that record, Lordship.
I need the record
I will place this.
because out here, unfortunately, I can't read the top
Yes.
that those corners. And but one thing, Mr. Das, it appears that the disqualification which they have mentioned in their affidavit is not here.
Lordship, here.
That is what you see now. No, but I have to see the record.
That production of fish, something to do with production of fish and what I have shown.
Lordship, here, one major thing, Lordship, this settlement order is, we could not found in the records, the annex settlement order earlier by.
Anyway, you bring the record best. I don't. Okay, this one. Ah, this is there.
This record is also there, settlement order record is also there. Kindly go to the original one. Original publication.
Before tender copy. He may suffer when the past record. Result of fish production is not good position as there is other problem.
Yes.
Maybe all the things is not. Okay, that is one of the reasons. Keeping in view the ecological aspect of the bill is concerned, result of fish production is not good position as there is other problems on the bill. Keeping in view the above. So it is not only the money.
Lordship, I'll leave it to your Lordship. It is our understanding that here, Lordship, one thing, Lordship, this page number 36, we could not find the record. That settlement was annexed earlier, and it is not in the record, Lordship. Different, my lord. Private respondent, settlement, my lord, order.
Look, I think I'm starting to enjoy the submission made by the. I think we'll hear it on another date. You see, it's taking a humorous turn. I think we'll hear it on some other day. It doesn't appear that you all have been fair.
In his, now.
It's up to your lordship, because it is our stand lordship. We consider that, I leave it to lordship. We as a, we are, when we place the order before the single bench, the single bench considered that it is in line with that writ petition because there is an exorbitant rate.
No. Leaving us that aside.
Lordship, kindly go to that.
No, I think-
that original order, original copy, that in.
Just write one thing. Just write one thing. Yes, no problem. When can we hear? This will take some time because they are. You see, the issue is actually with regard to the initial rejection of your bid.
Yes, my lord.
The initial rejection of your bid is not only on the aspect of money.
This is what, my lord.
It appears that it is not only on the aspect of money. Only problem is because of what has been stated by the division bench pertaining to another division bench order of WA 8. That doesn't matter, but now I'll have to justify all that, no? I'll have to clarify all that aspect. And he has not brought the single bench judgment
Yes,
order
lord, that is-
on the basis of which WA 8 has been made.
Yes, lord, that is, that has to.
So I'm not in a hurry to finish your case.
Sorry, one thing, lordship, here. Kindly, 1 minute, lordship, page number, we have stated in the affidavit, letter part affidavit, page number 36. Page number 36, kindly go to that. 36.
36 of what? The
Affidavit
repetition.
opposition, my lord. This is to clarify, my lord. Not it, then it-
Ah,
2 minutes only, sir. Because-
You took 2 minutes, 20 minutes back. 36, yes.
Yes, these documents we could not find in the record, official record. Lord. So the MD which filed this, signed this, he has already been suspended also. Lord. Earlier MD.
Yeah, other documents.
Here we have stated in the.
No, but then out here it gives some indication that there was something to that effect.
Okay, but we have taken, we have not. taken
You,
production.
huh?
Production part they've taken into
No,
consideration.
not it. Our consensus is that that
It is the requirement under the NIT, as I have shown. If you are in top, it has not come.
Well, okay, so these documents you cannot find, but it was there, was it? Was it there earlier?
No.
You do not.
the file which stated, it is of Telia Donor, it's Shivsagar file. The file number which is stated, lordship.
So this file you cannot trace.
This file is nowhere in the.
Where is the file number?
This is a memo, this is lordship. A memo number AFDC 486 2020 121A. This is relating to a Shivsagar fishery lordship.
So this memo number, there is a memo number only, but where is the
Yes.
file number? File number is what? AFDC 486 or what?
Yes, that is the file number.
That is the file number.
Yes,
So this file number is important.
this file number, I will bring it, this file number. This is for different fishery lordship. Actually, there was.
Why should I, in that other fishery file,
Yes,
this fishery is being
no.
considered
this-
or?
We are thinking that this is a concorded one, filed by the earlier MD, who was suspended and criminal cases also.
What was concocted? This 486 is concocted.
Yeah, this document. We have
This
stated-
document is concocted.
Yes, because we have, earlier we have not found after,
Okay.
in the affidavit also, we have stated in the, page number 162, lordship, we have stated this way.
Why don't we go for a fresh tender?
I think so, but it would be better.
I think that will solve everything.
Many people. will-
Otherwise, the way the things are going now, by the time I unravel all the things, I think the same order will have to be issued. Because this document out here gives an indication with regard to the fish production. So, yes, what do you say? You obtain instructions from a client?
Regarding.
Huh?
My lord, on the settlement part, my lord, the settlement part,
You obtain instructions, Mr. Counsel, no more arguments. You obtain instructions from your client. In the meantime, you bring the records. And even if your client says that he doesn't agree, then we'll have to pass orders to see that, the proper order, that she,
Yes, I have got one original order, Lordship, and it may go through, next year, Lordship. I have got a
we
letter.
have got some original order,
Yes, that is
which is to the, to what effect?
to that settlement order, where it is, that is the, in the file, Lordship.
What does it say basically?
Here, Lordship, it is, I have read it, Lordship.
You have read it?
I have read it, Lordship, beforehand. Is that
How does that help me? I have not read it,
what should I say to?
huh?
No, what he means to say, there are two settlement orders.
Yes, that much I know.
Give the reason,
Ah,
other give the reason in favor.
No, I'm not on that. That settlement order is not, that is the concorded one we are saying.
If
If Lordship allows, we can,
This
yes,
concocted one and other is they are saying it is original one.
that we could not find in the record. That order we could not find.
which is concocted,
That is the page 36 now.
36, my lord.
36.
36 is concocted.
Lordship, here, Lordship, here we have in the affidavit also we have the new MD has stated it, Lordship.
This is your document, this is concocted.
Yes, Lordship, earlier MD has filed it.
Original is this.
Who has been suspended, Lordship? Yes, he has filed it.
Where have you said in your affidavit that this is a concocted document?
Here, Lordship, here.
No, where have you said in your affidavit that this is a concocted document? I don't know, I think,
I will take all the records next day, Lordship. Lordship will find after going through the record, Lordship will go through. it.
I think so.
It will be better, Lordship.
You all have a duty to
Bring the record.
to clarify everything clearly for taking so much time. I've started out, I'm exactly where I started out. Still lost.
Lordship, tender going up with him. He was rejected. He also, if he agrees, I am asking him if he agrees for retender, Lordship. No. Another date fixed. So Lordship, I'm speaking like the original record.
Okay.
I'm not agreeing, but I'm giving it to you.
No, let him bring the record. And that single bench order regarding that, the basis for that WA8, bring that. And bring all the files.
Lots, all the files.
I can dispose, but it'll be hopscotch without all the documents. Mr. P. Sharma submits that he shall produce all the original records pertaining to the present case. And especially the reasons given in the affidavit in opposition for stating that the petitioner's technical bid was disqualified. Was this defective? Was defective? Defective, disqualified, unresponsive, same thing. Leaves the matter after the view vacated. Okay, give a date after the view vacation. We'll have no time before that.
24, Lordship.
24.
Not 24, my lord. After 26, my lord. 29, my lord. 24, there really. Oh, there is 8, Lordship. 29, my lord.
Okay, 29. Yes. 29.
Timing item
Oh,
7.
okay.
For further hearing.
I told you, I am exactly where I started out. I have not gained anything. In fact, I'm slightly more confused right now.
All right.
No, in this matter, the respondents have not filed their affidavit as of yet, my lord. We are fair price of dealers, my lord. We needed the POS system and the identity number by which we can, my lord, disburse the goods given to us.
Who is appearing?
Because under the consideration of the government, if they come up with an affidavit. 7 and 8. I think they're same, I'm like, it's the government. The matter was forwarded to the government also. I don't know, but we have copied the university.
So what is the case here? You have got a fair price shop, correct?
Yes, madam.
Ah.
And now to distribute the items of the fair price shop as given to us by the government, we are required to do it to the EPOS system, electronic point of sale system. Now to use that, my lord, we need an identity number.
Ah.
Now, this identity number, although available or there are vacancies for that identity number for all the shops, our numbers have not been allotted. So that happens, when that happens, I cannot distribute materials. That goes against me when they reevaluate me again. So we had made our applications and lordship will find that these applications have also been forwarded, processed and
What is,
sent to the
what is it called?
Madam, that is called an identity number, my lord.
Identity number.
Identity number, my lord.
For running the what machine?
POS, my
POS.
lord, point of sale. EPOS, my lord, electronic POS. So whenever a person comes to take the rice,
Yes,
he has to
madam.
give his fingerprint.
What to do?
Well, I'll pray, my lord, 3 weeks time.
Okay, right. Miss
We
Yudas.
from the last many months, my lord, we are not being
I-
able.
You have got a stay order in your favor.
My lord, they are not discontinuing us, but then without that number.
You cannot
we are not being
function.
able- We are not functioning.
I'll try to get it by that time, my lord.
By when?
I'll do my endeavor, my lord, after 3 weeks, my lord. 3 weeks time may be granted. My lord. It will take time.
Oh, okay, what date?
Prior to Bihu, my lord, so that at least I can distribute in Bihu.
Yes, at least he can get some free, he can get 1 or 2 sacks of rice for himself.
I wish, my lord, everybody should get rice, my lord, but,
9th April,
my
9th April. 3 weeks.
lordship,
Miss Yudas, learned counsel for the respondent submits that she did instructions to obtain the what number?
EPOS ID number,
EPOS
ID number.
ID number to enable the petitioner to run his FPS license shop. This is the matter online.
The interim order continues.
Interim order to continue till the next week.
Public.
It's a small issue. Just the number, that's all. Why do you need, why do you need 9th?
I'll have to write to the department, they will give, my lord, by that time. I'll do that.
You make a phone call, WhatsApp is easier. By the time you write, you take 20 minutes. By the time you send it, another 20 minutes. You give a call within 5 minutes and you talk to them.
That's correct in that, like,
Yes.
I would have to file an affidavit, my lord, I'll have to take instrument,
Sometimes-
comments and all that. My lord, I'll do the needful by that time.
No, the thing is that you see, he's got a shop.
Lordship is correct.
He wants to run it.
Lordship.
It's a genuine expectation
My lord,
for him to, Bihu is coming.
do my
they-
lord, and when, my lord, that is for the beneficiaries, are, my lord, so then
Correct,
only.
correct, for everyone.
Nah, I'll,
First week,
my lord, I'll try to get it, but my lord, 4 days are holiday there, my lord, saying, because from
okay,
Saturday,
we'll list it on
9th is, my lord, by that time, my lord, I'll.
Okay.
Deeply offensive.
item
I
eight.
will see.
How much time?
Lordship, 3 days time. But lordship, I wait for respondent 2, 3, 4 and 5.
Mr.
As Gautam, my lordship.
S.
Gautam.
Is granted 3 weeks time to file affidavit in reply.
3 days, 3 days.
3 days time
I did my fix.
to file affidavit in reply. Mr.
A Barbujari,
A. Borpujari is granted. No, it appears for the respondent
2, 3, 4 and 5.
2, 3, 4, and 5.
Interim order may be continued.
Interim order continue till the next date. This is the matter after
I did my fix.
vacation now. After Bihu vacation.
19.
Give a date after vacation. 18.
May I please, Lordship? Lordship, while issuing notice on 8/2/2024, Lordship had directed the department EPF to file an affidavit with regard to one dishonored state. For that, Lordship, we have given them a draft, whether that has been debited or not. Now, Lordship, in the meanwhile, till now, Lordship, in the month of February and March, Lordship, we have paid an amount of rupees 20,89,636. Now only only 9,88,000 still remains. So I pray for before your lordship to restore the installment payment as it was agreed upon.
So the installment payment was made with effect from which date? From which month? From May 2023, I think,
Yes,
correct?
Yes, Lord.
May
May
2023.
2020.
So from May 2023 till now, how many months have passed? 6, 7, 8. 8 months have passed, 9, 10. 10. With this month, it will be 11 months. Now, 11 months into 153,993 is how much? Calculate. 153,993 into 11.
Sixteen lakhs 93,000
16 lakhs 93,923.
923.
And how much have you paid?
Lordship has just given the. On 27th,
When was your last payment made?
last payment was made on 11/3/2024. 5 lakh.
11/3.
Lordship, that 3 days I have given lordship.
Acha, okay.
Lordship. 27/2024, I have given 1,54,000.
Yes.
Then 4/3 and 11/3 also I have. Only some 9,88,000.
8,725 is.
9 lakh
88,725 is.
88,725.
Yes.
So you let it continue.
No, Lordship,
He'll complete it by that time.
no, Lordship, they can pay with 1 month because in case it is a public money, poor people's money, no. Now they can.
You see, you yourself had allowed the installment plan.
Yes, that was the Lordship.
Now,
cancelled because-
you have also till date,
Yes,
you have not submitted your affidavit.
yes, Lordship, yes,
I'll give him time, 2 months time. Two months you file. In the meantime, you won't file.
Lordship, I would like to
Weeks
pay
time
for
given,
10,
I-
at least
Huh?
10.
only 2 weeks can be given, I'll go to the inspection, Lordship, yesterday, no, I'll submit, Lordship. My affidavit.
Yes, you submit. Don't be in a hurry. Take your
Yes,
time.
yes.
We'll give you time.
And Lordship, I have.
In the meantime, you carry on paying as per the installment plan.
Lordship, maximum Lordship, we have paid in the month of March, Lordship, we have paid at least 20 lakhs. Now Lordship may.
Month
kindly
of
give us-
March, you have paid
paid 13 lakhs, 13 lakh 18,000 plus 5 lakh 58,000. So Lordship may kindly.
19 lakhs.
Grant us 10 installments Lordship.
That-
For that 9 lakh 88,000.
No, you pay as per that 1 lakh 153. The same, you pay from April, 1 lakh 53,993. That means within
3 months time may maximum given, Lordship, because no, it will be, again, they will.
They have allowed us 25 installments. One
Okay.
default sake Lordship, we
Because
have
Lordship, why-
gave them the draft. Now where is the question of they are now preponing the Lordship thing Lordship.
Lordship, when issued warrant,
Earlier they were
they
issued-
started to payment, Lordship.
Ah,
That is the issue, Lordship. Again, we give it this liberty is public money, Lordship. After issuing warrant, this they are paying, Lordship. They are silent during those days, Lordship, 2 years and after years, Lordship.
And earlier
At
Lordship,
least 2 months we given, by these 2 months, they will clear the entire days, Lordship.
Lordship,
They
they
are
had earlier
100%
submitted that all our sakes have been dishonored. Lordship had, that is why Lordship directed them to file an affidavit. Lordship, we have paid our dues and we have paid our dues in advance in the month of March. Lordship has seen.
but then you
20
gave a
lakhs.
dishonored check.
Lordship,
You gave a check which bounced.
only one check has gone. That for that Lordship, we have given the draft Lordship. They have realized. And Lordship, that check was presented after the due date. So we thought that there may be, there are some Lordship, they have presented that particular check after the due date. They were supposed to present that check before the bank.
One mistake is enough.
Lordship.
You don't need 2 mistakes.
So Lordship, we are committed to pay. So that is why Lordship, we have already paid 20 lakh 89,000 during this February and March. So only 9 lakh 88,000 still remains. So I pray before Lordship to restore the Lordship installment payment and give us at least 10 months.
As per the installment payment plan, there's no question of 10 months. For the simple reason that as per the installment plan, you'd pay all this amount within 6 months.
No, 25 installment.
Huh?
25 equal installment.
Why?
Agreement was in regard to 25.
Maybe, but that is gone now. That is finished.
Cancel.
So my prayer is to restore that installment payment.
No, there's no question now.
Cannot be done. Unless
We can say, yes, we restore at the rate of 153, starting from April, you pay 1,53,993 per month from April.
that will be from the month of May, because this month we have paid.
No, nothing like that. You pay this.
We'll pay lots. We are committed.
Heard. Mr. S.K. Daswaran, counsel for the petitioners. Also heard Mr. D. Day, counsel for the respondents. The petitioners. Case is that in terms of the installment plan, which had been proposed by the petitioners and agreed to by the respondents, the petitioners were to pay rupees 1,53,993 per month as interest EPF dues in 25 installments. Full stop. The same was accepted by the respondents by letter dated 9/5/2023. Full stop. However, by letter dated, when is the letter dated? By notice,
9/1/24.
by notice dated 9/1/24, is it? Notice, page,
Page 37.
where you have been asked to pay the entire amount. However, by the notice dated 9/1/2024. No, you just said notice, you said letter dated 9/1/2024. The installment plan made between the petitioner and the respondent had been annulled, and the petitioner was directed to remit all dues amounting to rupees 30,78,991 with respect to RRC NEGHY/0003596/22/2021/501/35/401 dated 22/4/2021. Pusta. Page 37. Next, Mr. No, Mr. K, Mr. D, the learned counsel for the respondent. No, before that, the petitioner's counsel submits that though the respondents had taken the plea that the petitioner's check bearing number 075229 dated 10/6/23 was dishonored due to insufficiency of funds, the petitioner has now submitted checks. What are these numbers at the end?
Lordship, the first one is the Lordship, the and the second one are from SBI draft. Lordship.
Third one
Third one is also draft
has submitted
through SBI.
check dated 27/02/2024, bank draft dated 4/3/2024 and 11/3/2024, paying the respondents rupees 20,89,636 in the month of March 2024. Is this correct?
Yes, sir.
Yes, sir. They accordingly praise that the petitioner may be allowed to pay the remaining balance amount of rupees 9,88,725 as per the installment plan agreed to between the parties. Full stop. Mr. D. Day, learned counsel for the respondent, admits to the fact that the petitioner has paid 20,89,636 in the month of March 2024. Full stop. The counsels for the parties have agreed that the petitioner may be allowed to pay the installments, the remaining balance amount, though the number of installments is not being agreed to between the parties. On considering the above issue, this court is of the view that the petitioner should pay the remaining balance amount in terms of the installment plan made earlier. Accordingly, the petitioner shall pay 988,725 in installment in installments at the rate of rupees 1,53,993 every month, to be paid by the 7th of each month starting from April 2024 till final payment of the entire balance amount. The writ petition is accordingly disposed of.
Then the lawsuit will have to interfere with the impugn notice.
Wait, consequently, the impugn letter
13/12,
dated
2023 and 21.
no. Impugn letter dated
Page 16.
page.
Page 16.
Consequently, the impugn letter dated 13/12/23
And also 21/12, page next.
and 21/12/2023.
Lordship, still payment, Lordship, they are against us and.
Shall be kept in abeyance.
Yes, sir.
Shall be kept in abeyance till final payment of the due amount is made by the petition.
Lawsuit was disposed
Disposed of.
of. Right.
Lord, this is the application under the 11th things of the Arbitration Act for appointment of arbitrator. Lordship, to summarize the last event, Lordship.
I don't remember, I'll have to read.
Lordship, may kindly refer to the order dated 28/2. 20th February. May I read, Lordship?
Yes, sir.
Lordship, from para 5 is our contentions.
Ah.
The petitioner counsel submits that in terms of the judgment of the Delhi High Court in the case of Priyanka Takshood and others versus Sanuval Residency Private Limited, reported in 2022 HCC Online Delhi 4717. The Delhi High Court has held that adjudication of a dispute in terms of the arbitration clause between the parties was not barred by the existence of a concurrent remedy under the RERA Act 2016. The petitioner had also relied upon the judgment of the Honorable Supreme Court in the case of Srimati Hemalata Devi and others versus B. Uday Sri, reported in 2023 HCC Online SC 1686, where the Supreme Court has referred to another of its judgment, that is Messrs. MR MGF Land Limited versus Aftab Singh, reported in 2019 12 HCC 751, and held that an option is left to the party to choose between a public or private forum, and the party may choose to go for a private forum. Para 63 of the judgment states as follows. We may, however, hasten to add that in the event of a person
entitled to seek an additional special remedy provided under the statute, does not opt for the additional special remedy and he is a party to an arbitration agreement, there is no inhibition in disputes being proceeded in arbitration. It is only the case where specific special remedies are provided for and which are opted by an aggrieved person, the judicial authority can refuse to relegate the parties to an arbitration. The petitioner's counsel submitted in the case of Imperial Structures Limited versus Anil Patni and another, reported in 2020 10/73. The Supreme Court held that merely because the registration of the RERACT is valid till a certain date does not mean that the entitlement of the lottery concerned to maintain an action stands deferred in terms of the extension given to the validity of the registration of the builder under the RERACT 2016. He submits that in terms of the said judgment, the period for the purpose of section 18 has to be retained in terms of the agreement and not the registration under the RERACT. Lordship, then their part comes in. On the other hand, the learned counsel and the respondent submits that in terms of the judgment of the Honorable Supreme Court in Vidya Jolia and others versus Durga Trading Corporation, reported in 2021 2 SCC 1 at para 55 to para 58 and 78 and 79, the doctrine of election to select arbitration as a dispute resolution mechanism by mutual agreement is available only if the law accepts the existence of an arbitration as an alternative remedy and freedom to choose is available. Further, the Supreme Court in Vidya Jolia had held that disputes which are not to be adjudicated by DRT under the DRT Act are not arbitrable, as the DRT Act is a complete code by itself, so far as recovery of debt is concerned. Thus, submits the same analogy will be applicable in respect of the RERA Act. The learned counsel of the respondents has also relied upon the judgment of the Supreme Court in the case of NTPC Limited versus SPML Infra Limited, reported in 2023 9 SCC 385 at para 25 to 28, wherein the Honorable Supreme Court has held that the first inquiry to be made in respect of 11(6)(a) of the 1996 Act would be with regard to the existence and validity of an arbitration agreement, and secondly, as to whether the dispute was arbitrable. Now, Lordship, I need to make a distinction on the Vidya Jolia judgment because
Wait, just tell me again the facts of the case. I
facts
forgot.
of the case,
Some,
Lordship, like that.
you bought a flat.
Yes, Lordship. We had entered into an agreement with them for purchase of a flat. The same flat was to be handed over to us by December 2020, as per the contractual terms. As per the contractual terms, we had also paid 95% of the consideration now. Since they have not till date handed over the possession, so we become entitled for compensation in terms of section 18 of the RERA Act, and that is the point to be adjudicated by the arbitrator. And hence we are picking the.
So as per there's an arbitration clause.
Yes, Lordship.
And the arbitration clause provides that there'll be one arbitrator.
No, Lordship.
Three.
It consists of 3 arbitrators.
If there's 3 arbitrators, have you appointed your
Yes,
arbitrator?
Lordship, we are appointed.
And you have given him notice
Yes,
for the appointment
Yes, Lordship.
and he has not accepted.
Yes, Lordship.
So you have come here.
Yes, Lordship.
Now your case is that the arbitrator should be appointed. His case is that it should go under the RERA Act.
Yes, Lordship.
So the question is, where should it go?
Lordship.
So the
Lordship,
question is,
according to my submission, Lordship, it will go to the arbitration. Because Lordship, he is relying on the Vidya Jolia judgment. Vidya Jolia was held that DRT cases are not arbitrable, and I want to make the distinction there because DRT Act is a complete code in itself. Lordship, I want to make the distinction there because here in the Vidya Jolia judgment, it was held that when arbitration as an alternative mechanism is to be chosen, what is to be examined is if there is any inconsistency or repugnancy in the between the mandatory law and arbitration as a alternative.
no, okay, one thing. The interest payable,
Lordship.
which you are claiming,
Lordship.
is under what provision
Under 18, section 18
of the RERA Act?
of the RERA.
So why isn't it convenient for you to go under the RERA Act to
So,
claim the
Lordship,
same thing
Lordship,
that
under
you're
the
claiming here?
doctrine of election, the choice is with us as a home buyer. We can either go for Consumer Protection Act, we can go for arbitration, or we can invoke the proceedings of RERA. So every fora has its own pros and cons, Lordship. But we as a consumer, we feel that arbitration will be a better alternative, better remedy fora for us. So we have chosen the fora of arbitration. Lordship, there have been cases where the consumers have chosen the forum of consumer protection. There the builders come in and say that no, this is not the correct fora, we go with the arbitration. Lordship, that is the judgment which I'm relying on. But the Honorable Supreme Court.
That is with regard to consumer forum and
Consumer forum. But Lordship, there the Supreme Court has held that where there is a choice between public fora and the private fora, the other party is at liberty to choose between the public fora and the private fora. It is his choice. It is the consumer's choice.
but when there is an arbitration clause,
Lordship.
so that's why the doctrine of election
Lordship.
allows you to go for
Lordship.
arbitration.
Lordship, and also Lordship, the doctrine of clean hands. Because the agreement was enacted after the RERA provisions came into force. Knowing being very full aware that RERA provision is there, they chose to incorporate the arbitration clause and without any express that these are the conditions on which arbitration.
No, but RERA would only cover a certain kind of dispute. It will not cover each and every kind of dispute.
Lordship, but that is not expressly mentioned as to when arbitration is to be invoked and when it cannot be invoked. There is no exclusion in the.
Okay, then now you'll have to distinguish.
Lordship, while distinguishing the Vidya Tolia case,
Yes.
why DRT, the analogy will not be applicable in the instant case. Lordship, may kindly have the RERA Act section 18.
Section 18.
18.
Yes.
Lordship, if the promoter fails to complete or is unable to give possession of an apartment, plot or building in accordance with the terms of the agreement for sale or as the case may be duly completed by the date specified therein, or due to the discontinuance of his business as a developer on account of suspension or revocation of the registration under this act, or for any other reason, he shall be liable on demand to the allotee in case the allotee wishes to withdraw from the project without prejudice to any other remedy. Lordship, this is where I place my emphasis. I'll come back to this later part. But for the time being available to return the amount received by him in respect of the department, plot, building, as the case may be, with interest at such rates as may be prescribed in this behalf, including compensation in the manner provided under this act. Provided that where an allotee does not intend to withdraw, Lordship, this is our case, does not intend to withdraw from the project, he shall be paid by the promoter interest for every month of delay till the handing over of the possession at such rates as may be prescribed. Now, Lordship, the process for adjudication of the dispute is there in Lordship section 71 of that. Lordship, may I come to section 71. Power to adjudicate. For the purpose of adjudging compensation under section 12, 14, 18 and section 19, the authority shall appoint in consultation with the appropriate government one or more judicial officer as deemed necessary, who is or has been the district judge to be an adjudicating officer for holding an inquiry in the prescribed manner after giving any person concerned a reasonable opportunity of being heard. Now, Lordship, this provision is akin to section 19 of the Recovery of Debt Duty Banks and Financial Institutions Act. Lordship, may I have the act for a while? This is only adjudicating the dispute.
Section?
Section 19, 19(1).
Yes.
Where a bank or a financial institution has to recover any debt from any person, it may make an application to the tribunal.
Just a minute, just a minute.
Jurisdiction.
Yes. Where a bank?
Where a bank or a financial institution has to recover any debt from any person, it may make an application to the tribunal within the local limit of whose jurisdiction. So, Lordship, it goes on. So, ultimately, Lordship, after the adjudication has taken place, the DRT will issue a recovery certificate under section 19, subclause 22 of this clause. Lordship, then the question of recovery comes in the picture. Now, Lordship, may kindly come to section 25, the modes of recovery.
Mode of recovery.
Modes of recovery of debts. From section 25 to section 29.
Yes.
The recovery officer shall have receipt of the copy of the certificate under subsection.
No, section 29.
25, Lordship.
25.
25, 26, 27, 28, 29,
Yes.
all of the 25, Lordship. Modes of recovery of debts. The recovery officer shall on receipt of the copy of the certificate under subsection 7 of section 9 proceed to recover the amount of debt specified in the certificate by one or more of the following modes, namely attachment and sale of the movable or removable property of the defendant, taking possession of property over which security interest is created, or any other property of the defendant and appointing receiver for such property and to sell the same, arrest of the defendant and his detention in prison, appointing a receiver for the management of the movable or removable property of the defendant, any other mode of recovery as may be prescribed by the settled government. Now, Lordship may kindly come to section 29. Application of, Lordship, have it?
Yes.
Application of certain provisions of Income Tax Act. The provisions of the second and third schedules to the Income Tax Act 1961 and the Income Tax Certificate Proceeding Rules 1962 as imposed from time to time shall as far as possible apply with necessary modifications as if the said provisions of the rules referred to the amount of debt due under this act instead of the Income Tax Act. So, Lordship, this special modes of recovery.
No, just tell me what does this mean?
Lordship, that the recovery officer while recovering while recovering the recovery certificate, he can take the help of the provision of the second and third schedule of the Income Tax Act to recover the recovery certificate. Now, Lordship, this is where the distinction lies. The Honorable Supreme Court held that if the DRT is to be arbitrable, in arbitration, adjudication can be done. But the other modes of recovery, that is from section 25 to 29, will not be available. That will defeat the entire object of the act. That is, efficacious adjudication and efficacious recovery of the debts of banks and financial institutions. That very object will be defeated because these modes of recovery of resorting to the second and third schedule of Income Tax Act, these will not be available in case of arbitration. This is where the distinction is, Lordship. Lordship will find in the Vidya Dole judgment itself. Lordship can have the Vidya Dole judgment.
No, so in this RERA Act,
Lordship.
isn't there a provision for mode of recovery?
No, Lordship. It's not there.
Huh?
It is only mentioned that this to be recovered as areas of land revenue. Section 40. There are no specific provisions by which it can be recovered. And more important, Lordship, the apex court in Vidya Jolly had held that the object of the act will be defeated in recovery of banks and this DRT Act. The very object of the act will be defeated.
If such disputes were decided by the arbitrator.
Yes, Lordship, because the other modes of recovery will not be available to the banks. So it is the banks who will be at a loss.
So your basic contention is because RERA doesn't have that mode of recovery.
Lordship. And
So,
also, Lordship, the function of the RERA as prescribed under section 34, that is in no manner.
so it is not a complete code in itself. That's what you're saying, or what?
Yes, Lordship. And also the object and purpose of the act will not be defeated. If arbitration is chosen as an alternative remedy, that is what Lordship the Vidya Jolly judgment says. That what the court is to examine is that if there is any repugnancy or inconsistency between the mandatory law and arbitration as an alternative. And this can be done by going through the text of the statute, the legislative history, and the inherent conflict.
Does it say that?
Yes, Lordship, in the Vidya Jolly judgment. Lordship, may I have the judgment one? I'll point out.
Or I thought we just have to have a prima facie view of whether there was an arbitration clause.
Lordship, that is definitely there. NTPC Lordship, eye of the needle.
Oh, yes.
The Vidya Jolly judgment, Lordship.
Just a minute before that, I just wanted to say section 18. Be liable to, be liable on demand. You shall be liable on demand to the allottees. In case the allottee wishes to withdraw the. I don't have it here.
2021.
I think it's a long judgment. It's a very long.
Very
judgment.
long. It's a very long judgment.
2021 to SCC.
Lordship may kindly come to para 55. Page number
Yes.
63, Lordship. Lordship, the 11th line.
53.
Page number 63, para
Ah,
55.
55. Okay.
Lordship, the 11th line. When arbitration cannot enforce and apply such a,
Yes.
I'm sorry, Lordship, the entire paragraph will be required.
Okay.
I'll read the entire paragraph. Doctrine of election to select arbitration as a dispute resolution mechanism by mutual agreement is available only if the law accepts existence of arbitration as an alternative remedy and freedom to choice is available. There should not be any inconsistency or repugnancy between the provisions of the mandatory law and arbitration as an alternative. Conversely, and in a given case, when there is repugnancy and inconsistency, the right of choice in election to arbitrate is denied. This requires examining the text of the statute, the legislative history, and the inherent conflict between the arbitration and the statute's underlying purpose. With reference to the nature and type of the special rights conferred and power and authority given to the courts or public forum to effectuate and enforce these rights and orders passed. When arbitration cannot enforce and apply such rights, or the awards cannot be implemented and enforced in the manner as provided and mandated by law, the right of election to choose arbitration in preference to the courts or public forum is either completely denied or could be curtailed. In a sense, it is necessary to examine, Lordship, if the statute creates a special right or liability and provides for the determination of each right or liability by the specified court or the public forum so constituted, and whether the remedies beyond the ordinary domain of the civil courts are prescribed. When the answer is affirmative, arbitration in the absence of special reasons is constituted. The dispute is non-arbitrable. Now, Lordship, with respect to the DRT Act, Lordship, kindly come to para 50.
Just let me read it. Yes.
Lordship, may kindly come to page 65, para 58. I'll not read the entire paragraph, only the relevant part I'll read.
Page 65.
Page 65, Lordship. The second line.
Yes.
However, non-arbitrability may arise in case of the implicit prohibition in the statute conferring and creating special rights to be adjudicated by the courts public fora, which right including enforcement of the order provisions cannot be enforced and applied in case of arbitration. To hold that the claims of the banks and financial institutions covered in the DRT Act are arbitrable would, Lordship, this part is important, would deprive and deny the institutions of the specific rights, including the modes of recovery specified in the DRT Act. Therefore, the claims covered by the DRT Act are non-arbitrable and there is prohibition against waiver of jurisdiction by DRT by necessary implication. The legislation has overridden the contractual right to arbitration. So, Lordship is saying, the Honorable Supreme Court is saying that since the banks will be deprived from enjoying the special modes of recovery, that will defeat the entire object of that, and hence these are non-arbitrable. So, Lordship, the bank's rights are getting hampered if arbitration is to be continued for DRT matters. In the instant case, Lordship, the promoter in no way will be prejudiced if arbitration is chosen as an alternative remedy. Neither will the object of the RERA Act be defeated, nor will it interfere with the functions of RERA Act under Section 34.
No, but what prejudice will be caused to you
Lordship.
if you go under the RERA Act?
Lordship, every forum has their own pros and cons. RERA is an act wherein there are multiple levels, like the order passed by the adjudicating officer can be appealed before the RERA Act. The RERA Act order can be appealed before the High Court. There is a statutory provision of appealing under the High Court.
Similarly,
RERA Act.
here also,
But Lordship, in arbitration, once an award is passed, Lordship, the ADR itself, the concept is that efficacious and speedier disputes of resolution of.
but there's no bar to go under 34 or
Lordship.
37.
But Lordship, again, the scope
Okay,
is very
yes,
limited.
scope is
So
limited.
every forum, Lordship, has its own pros and cons. So the choice is, Lordship, with us, the consumers. In fact, Lordship, in this Vidya Dole judgment that they are referring to, Lordship, landlord and tenant matters,
Huh?
for long, landlord and tenant matters, dispute between landlord and tenant matters, therefore long held to be not arbitrable. Starting from Bruce Allen and Hamilton Incorporated, it was held that landlord tenant matters are not arbitrable. Even in case of Himangani Enterprise, it was held the same. But thereafter, Lordship, in Vidya Dole judgment, the Supreme Court overheld the thing. Overruled that and held that landlord tenant judgments will also be landlord tenant disputes will also be arbitrable because they arise from rights in personam. Of course, Lordship, there is a caveat that until and unless if a special act is conferring special power which can be decided by a court or a tribunal, then it would not be applicable. But otherwise, it will be applicable. Lordship, my second fold of the argument will be the question as to whether the right that is available to me under Section 18, whether that can be, whether there is any bar for answering the grievance by any other fora, was answered by the Honorable Apex Court in inferior structures.
So your proposition is that due to section 18,
Lordship.
whether that can be a bar for you to approach the arbitration.
Lordship, whether I can approach, whether under Section 18 is only applicable, I have to go to RERA, or it can be decided by other tribunal or other foras as well. So, Lordship, this is what has been held in this Supreme Court judgment.
Imperial to have got.
Yes, Lordship.
Yes, you can take this back, I think.
Lordship, para 25,
I have 25.
Lordship.
Yes.
In terms of Section 18 of the RERA Act, if a promoter fails to complete or is unable to give possession of an apartment duly completed by the date specified in the agreement, the promoter would be liable on demand to return the amount received by him in respect of that apartment if the allottee wishes to withdraw from project. Such right of an allottee is specifically made without prejudice, Lordship. This is what I was referring to. Without prejudice to any other remedy available to him. The rights so given to the allottee is unqualified, and if availed, the money deposited by the allottee has to be refunded with interest at such rates as may be prescribed. The provision to Section 18 subclause 1 contemplates a situation where the allottee does not intend to withdraw from the project. In that case, is entitled to and must be paid interest for every month of delay till the handing over of the possession. It is up to the allottee to proceed either under Section 18(1) or under Proviso 18(1). Lordship, our case will come in the later category.
What does the proviso say?
Because Lordship, we are not asking for cancellation of we don't want the money back. We just
That much
want the
I know,
compensation part
Yeah.
till the flat is handed over to us.
But what does it mean when it says the proviso? What does the proviso provide for?
So Lordship, there are two options under Section 18. One is that I cancel the apartment, I take my money back along with the interest. The other
Or
provision,
you claim interest?
I get a compensation. Lordship, that is what the second provision is. So Lordship, carry on. The case of Himanshu Giri came under the latter category. The RERA Act thus definitely provides a remedy to an allottee who wishes to withdraw from the project or claim return to his investments. Now, Lordship, para 26. It is therefore required to be considered whether the remedy so provided under RERA Act to an allottee is the only and exclusive modality to raise a grievance, and whether the provision of the RERA Act bar consideration of the grievance of an allottee by other fora. Lordship, here is where it answers. Section 79 of the RERA Act bars jurisdiction of a civil court to entertain any suit or proceeding in respect of any matter which the authority or the adjudicating officer or the appellate tribunal is empowered under the RERA Act to determine. Section 88 specifies that the provisions of the RERA Act would be in addition to and not in derogation of the provisions of any other law. While in terms of Section 89, the provisions of the RERA Act shall have effect notwithstanding anything inconsistent contained in any other law for the time being in force. On plain reading of Section 79 of the RERA Act, an allottee described in Clause B stated in para 24 herein above would stand barred from invoking the jurisdiction of a civil court. However, as regards to the allottees who can be called consumers in the meaning of Consumer Protection Act, two questions would arise. A, whether the bar specified under Section 17 of the RERA Act would apply to proceedings initiated under the provisions of the Consumer Protection Act, and B, whether there is anything inconsistent in the provisions of the Consumer Protection Act with that of the RERA Act.
Let us see 79.
Lordship. Bar of jurisdiction, Lordship. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which the authority or the adjudicating officer or the appellate tribunal is empowered by or under this act to determine, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this act. Now, Lordship, there is a judgment of the Honorable Bombay High Court when it has been held that arbitral tribunal is not civil court within the meaning of civil courts. Okay.
But is it a judicial authority? An arbitral tribunal,
Lordship.
is it a judicial authority?
Lordship, even Consumer Protection Act is a Consumer Protection, the tribunal is also judicial authority.
Okay, yes. So what do you want to see? What do you want to show me here?
Lordship, the Bombay High Court judgment kindly come to para 9.
Just what is this? 2020. Yes.
Having heard Mr. Kode and having perused the recording so far as first contention on the issue of RERA is concerned, it clearly appears from the scheme of RERA that the same has been enacted for regulation and promotion of the real estate sector and to ensure sale of plot, apartment or building as the case may be, or sale of a real estate project in an efficient and transparent manner, and to protect the interest of consumers in the real estate sector, and to establish an adjudicating mechanisms for speedy dispute redressal, and for such purpose to establish an appellate tribunal to hear appeals from the decisions, directions, or orders of the real estate regulatory authority and the adjudicating officer, and for matters connected therewith. As to what is import of provisions of Section 79 would be required to be seen. Section 79 creates a bar on the jurisdiction on the civil court to entertain any suit or proceeding in respect of any matter which the authority of the adjudicating officer or the appellate tribunal is empowered by or under RERA to determine, and a further bar to any injunction being granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under the RERA. Thus, primarily Section
Just a
79.
minute.
Lordship.
So section 79 creates a bar on the jurisdiction on the civil court
Lordship.
to entertain any suit or proceedings in
Lordship.
respect of any matter which the authority of the adjudicating or the appellate tribunal is empowered by or under the RERA to determine, and a further bar to any injunction being granted by any court or other authority in respect. So this other authority would mean what?
Lordship, this is what the judgment is discussing.
Yes.
Lordship, may I continue?
Yes.
Thus, primarily Section.
No, so this other authority could be this.
It's discussed here, Lordship.
Okay.
Thus, primarily Section 79 postulates a bar on the civil court to exercise any jurisdiction to entertain any suit or proceedings. And also that no injunction shall be granted by any court or any other authority as provided in the concluding part of the said provision.
Yes.
Lordship, after that, para 10. The arbitral tribunal certainly cannot be a civil court falling under the Code of Civil Procedure. In such context, it may be useful to refer to the decision of the Supreme Court in Food Corporation of India versus Messrs. Evodem Corporation, AIR 1999 SC 2352. In such decision, the Supreme Court had the occasion to interpret the phrase civil court as falling under Section 2, Subclause C of the Arbitration Act 1940, to observe that the phrase civil court having jurisdiction to decide as containing Section 2C of the Arbitration Act 1940 would refer to a court having jurisdiction under Section 20 of the CPC. In paragraph 5 and 6 of the said decision, the Supreme Court, considering the legal provision of the jurisdiction of the civil court under section 20 of the CPC vis-a-vis its applicability to clause 12 of the letters patent of the Bombay High Court, observed thus. Under section 2C of the Arbitration Act 1940, court means the civil court having jurisdiction to decide the questions forming the subject matter of the reference if the same had been the subject matter of a suit. Under section 31, subclause 1 of the Arbitration Act 1940, an award may be filed in any court having jurisdiction in the matter to which the reference relates. Ordinarily, the phase civil court having jurisdiction to decide in section 2, subsection C of the Arbitration Act 1940 would refer to a court having jurisdiction under section 20 of the CPC. Section 20, subclause A of the CPC provides, subject to the limitation aforesaid, every suit shall be instituted in a court within the local limits of whose jurisdiction a defendant or each of the defendant, where there are more than one, at the time of commencement of the suit, actually and voluntarily decides or carries on business or personally works for gain. C. The cause of action wholly or in part arises. In the present case, no part of the cause of action has arisen within the jurisdiction of the Bombay High Court. We have therefore to see whether section 20A would confer jurisdiction on Bombay High Court as has been held in the impugned judgment. Section 20 has to be read along with the explanation to section 20, which provides as follows. Explanation. A corporation shall be deemed to carry on business at its sole or principal office in India or in respect of any cause of action arises at any place where it also has a subordinate office at such place. In view of this explanation, the appellant under section 20 is deemed to carry on business at its principal office in India in respect of any cause of action which arises at a place where it is has its subordinate office. The court at that place would also have jurisdiction. In view of the explanation, the Bombay High Court would have jurisdiction under section 20 of the CPC. To appreciate the arbitral tribunal is not a civil court.
This is the Bombay High Court would not have.
Lordship.
Yes, then.
To appreciate that the arbitral tribunal is not a civil court, it would also be useful to refer to the decision of Supreme Court in Nahar Industrial Enterprises Limited versus Hong Kong and Shanghai Banking Corporation, 2009 at SCC 646. In the context where the arbitral tribunal is a civil court, the Supreme Court observed thus, whether tribunal is civil court. The terms tribunal court and civil court have been used in the court differently. All courts are tribunals, but all tribunals are not courts. Similarly, all civil courts are courts, but all courts are not civil courts. It is not much in dispute that the broad distinction between a court and a tribunal is whereas the decision of the court is final and the decision of the tribunal may not be. The tribunal, however, which is authorized to take evidence of witnesses, would ordinarily be held to be a court within the meaning of Section 3 of the Evidence Act 1872. It includes not only judges and magistrates, but also persons except arbitrators legally authorized to take evidence. It is an inclusive definition. There may be other forums which would also come within the purview of the said definition. Lordship, thereafter the Honorable Bombay High Court concludes, adverting to the above position of law, it can be observed that although the arbitral tribunal has some trappings of the court, the arbitral tribunal is not a civil court within the meaning and purview of the CPC so that the bar to arbitral tribunal can be a proceeding under Section 79 of the Raid Act.
Okay, that is one aspect, but does it come under the meaning of the word authority?
Lordship may kindly have the imperious structure judgment. So, Lordship, in that case, what was happening is that the Supreme Court was examining as to whether the bar of Section 79 would be a bar for a consumer to elect his choice under the Consumer Protection Act.
You see, because
Lordship.
it also talks of any other authority.
Lordship, it takes into consideration, Lordship. Because consumer protection is any other authority, it's a judicial forum, Lordship. Lordship, when the Supreme Court is saying that you can go to consumer protection, Lordship, consumer protection is not a civil court, but Lordship, that is what it says here, that it's a judicial authority.
So consumer forum is a judicial authority.
Lordship.
Tribunal is also an arbitral tribunal. Will it be a judicial authority?
Lordship. So if consumer protection can be enforced, can adjudicate Section 18 grievances, Lordship, definitely arbitral tribunal can also. Lordship, may kindly come to para 29 of the imperial judgment. Lordship, here it is again referring to the Nahar Industrial Enterprise.
No, let us see it.
Lordship.
Page, it starts with paragraph, no?
Lordship, sorry, para 13 discusses Lordship's concern, other authorities.
Yes.
Lordship. In the Bombay High Court judgment, Lordship. I missed that part, Lordship. Lordship, para 13. Insofar as the second part of the section 17 is concerned, it provides that in respect of matters falling within jurisdiction of the authority of the adjudicating officer of the appellate tribunal under RERA, no injunction shall be granted by any other court or any other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under RERA. Thus, when it comes to grant of injunction, the provisions of section 79 refers to two significant phases. Firstly, the phase by other court, by any court, and or other authority. The learned arbitrator has proceeded on a footing that the arbitral tribunal would be an authority, hence it falls within the purview of section 79 and consequently would be barred from making an order of injunction. In my opinion, the tribunal is not correct in adopting such approach in interpreting section 79 so as to apply the bar under section 79 to arbitration proceeding before an arbitral tribunal for more than one reasons as may be discussed. To find out the intent, Lordship, it goes on to length as to why it's so. But Lordship, my submission in terms of the Supreme Court judgment of the imperial superstructure is that if Lordship, consumer protection as an alternative remedy can be elected by the consumer, Lordship, there is no bar for the arbitral tribunal. And Lordship, this judgment of the imperial structure, Lordship, the judgment I'm relying on the Delhi High Court judgment, which is very specifically answering the question as to whether arbitration can be invoked in view of the RERA provision. This judgment has been referred to Lordship, this very specific part, imperial structure.
So that consumer forum thing is in this imperial structure.
Imperial structure, Lordship. Lordship, may kindly have a look on para 30.
How long will it take?
Take some time.
It'll take some time.
Lordship, I'll make the distinction.
Oh, I've got an interview with J1 and J2 at 4:30. I've got to hold interview, I forgot.
Lordship, has had the matter in full length. Lordship, may kindly keep it as a part hard matter.
Let it come after verification.
No, Lordship,
After verification.
kindly before that, Lordship. Lordship, they are not giving us possession of the flat, not even compensation. Now they are even
But
reporting.
why are you paying? For giving them the flat?
Flat, we are already in the fire license, there is a story to it also, which I had on the last occasion.
Lordship, again, he's submitting facts without affidavit.
No, that's.
Unfortunately, I've got an interview. Got to hold an interview.
Lordship, may kindly have it before the invocation.
My lord, in item number.
Item 21. How many matters have you got left? 5. Oh, very slow we went. Oh, Mr. Datta's recovery case is also there. Which one? Huh?
Number 20, that recovery case.
Recovery case is there.
The review petition, actually, it's an appeal in the.
I don't know. We have to hear them first.
Yes, your Lordship will fix the matter immediately.
We'll do it after Bihu. No time before Bihu. Huh? Interim order. Okay, right. Item 20. This is the matter. After Bihu, give a date. Interim order to continue till the next date. Huh? Then who else?
My lord, item number 27, my lord.
27. Yes.
Hearing, that will be taken up on 28th, my lord.
This no. I have no time. We are packed.
I know, my lord, but that, it's a very small matter.
All their cases are very small.
Then can it be on, my lord?
Yes,
On
please.
eighth-
I've got to go.
On 8th or 9th?
8 or 9. 9, okay.
27.
Item number 27.
21, what do you want?
27, 9 of.
Huh? Delay in registration. Acha, okay. 21, you put it.
Item number
28.
item number 24, my lord. It may be fixed on 2nd of April, my lord. But
Item
the-
21.
24, my lord.
24.
There is an interim order, my lord.
What is this regarding?
Regarding allotment of RO retail,
He said he has not received the email, my lord, but he is deleted from his inbox, my lord.
Okay. Whether he has received that mail or not.
He has
Yeah,
received, but he
my
has
lord,
deleted it
mail,
from his inbox, my lord.
Okay, and you have got that
Video, my lord.
video?
Yes, my lord. We made a video, my lord. We have shown him, my lord, how it is kept in the trace file, my lord. From his own mobile phone.
Okay, right.
On part, my lord.
This one is a tender matter.
Yes, my lord.
There's stay order.
Yes, my
yes, my lord. Status quo order is there.
Is it? Okay, first,
My lord, interim may be continued.
interim order to continue to the review.
Lordship,
How long will you take?
Lordship, I will not take much time.
Not take much time means how long?
Lordship, 20 minutes at the max.
That means half an hour.
You?
I'll at least
Lordship,
take
I have prepared a short
At
note,
least-
Lordship. If Lordship
Huh?
allows
at
me,
least half an hour. Because he has all the points that he has.
Difficult, bring the council. You know now, we're in a rush now.
So,
People are
Let it
really.
come after me.
Lordship,
That's what
can
I'm
we,
saying.
can we have it on the 7th of April?
No.
On 8th of April, Lordship, 9th of April?
No, 9th I'm out of state. It's 7th or 8th.
I will not be here for that. I will not. I will
Let it come
not.
after me.
Lordship, after me.
And then after that, I have to be in Calcutta also.
Lordship, 23rd then? 23rd.
25th.
25th, can it be 23rd?
25th. Thursday. No,
Then Lordship, 30th.
30th. 30th.
Okay, right. Unless the
Lordship, in
matter
the
of
meanwhile,
30.
Lordship had asked us to prepare a written submission of our, Lordship has prepared that. Lordship,
Lordship, I'll be providing after the comprehensive, all the hearing is done. So it's piecemeal when I want.
No, I thought you all won't take that much time.
No, he distinguished the thing, the 2 points that about the consumer protection, that part I need to clarify, Lordship.
Because okay. But what to do? There's a meeting. Not meeting, interview.
Please.
Not that is it.